Fighting this timeline with snark. Every soul welcome, but no recorders. Baptized by laughter in the dark. We stand tall, scorning fake orders. In the church of glory rise, with chaos and shenanigans bright. Chocolate and sarcasm uprise. Together we light up the night.
Hey everyone, and oh my goodness, I have to show you guys this because I feel like Neo. I am not going to lie. I know I already started off on a tangent, but I was able to figure out all by my own self, which, is a feat in and of itself, how to put my new overhead mount up. So I will no longer have a janky camera. In theory, we're going to get this figured out. I will not be cross stitching today because I'll be reading, but I was just so darn proud of myself for getting this put together. I had to celebrate myself. I didn't give myself a full accomplishment shower, but I did, want to point out, hey, I figured out something technical, which is, again, an oddity of epic proportions for me. Thank you all for joining. We are going to be looking at both the complaint against Linda Stanley, the head prosecutor or leading prosecutor in the Suzanne Morphew case, and sort of the failed prosecution of Barry Morphew, and see what she was getting into. Now, I will tell you guys that the complaint is 20 pages long, so this heifer went full thunder cow, allegedly in Minecraft. And yes, I am wearing my get off your moral high horse patch. I will be on my moral pony, my moral mini horse today, because I didn't commit prosecutorial misconduct to this point. I mean, it is rare that a sitting prosecutor gets a recommendation for disbarment. So we will be seeing what the heck was going on. I did want to let you guys know this is not a case that I have followed. I mean, I did random stories on Newsy News, but this is not a case that I have had a lot of time, I know, in depth. And I thought it would be interesting for all of us. You may also be new to the case, or you may know everything about the case. But I do like kind of how Baker let me come on to his Karen Reed case, streams, and I really didn't know all the players. So it is an interesting outlook to have someone who's never really looked at the case in depth coming up with, maybe fresh eyes. So that's kind of the spin we're doing on this. But let's get into this. So the Supreme Court for the state of Ohio, in discipline before presiding disciplinary judge, the people of the state of Colorado, I sure hope they had someone in a cardboard cutout representing, Colorado. And it looks like, well, just everyone is getting into this. But let's see. The complaint is filed pursuant to the authority of CRCP 242.15, 242.16, and 242.25, and is alleged as follows. Ooh, alleged. Talk legal to me, babes. Let's see. The respondent has taken and subscribed a oath of admission, was admitted to the bar of this court on October 29th, 2012, and is registered upon official records of this court, registration number 45298. Ooh, they get their own convict numbers. I like it. Y'all, this is going to be a super petty stream. It's going to be full of all the snark and general mowness. So just forewarned, and is, just be warned. I feel all the petty today. So join me on this, epic journey through the petty verse. I'm your tour guide here. 2, the respondent is subject to the jurisdiction of this court in these disciplinary proceedings. The respondent, I'm not going to give her address. Now, 3, the respondent is elected district attorney for the 11th Judicial District, which includes Fremont, Chaffee, Park, and Custer counties. 4, the respondent won her campaign for district attorney in November 2020 and took office in January in 2021. 5 months prior to her election on May 10th, 2020, Suzanne Morphew disappeared, and a massive search and rescue effort ensued, along with potential criminal investigation involving the FBI and CBI. Now, 6, the Chaffee County Sheriff's Office and other law enforcement executed hundreds of search warrants. Justin Smith, yes. We are going over the disciplinary, first, the complaint of all the disciplinary shenanigans that were alleged for the head prosecutor to have done. And we'll probably have to break this up and do the rest on Wednesday, because the complaint itself is 20 pages long, and like adjudication, opinion opposing and imposing sanction is 83 pages long. So we have a lot to get into as far as what this prosecutor was doing. Now, the Morphew case was highly publicized, and hundreds of community members participated in their own searches for Suzanne Morphew. 8, the respondent was aware that of the Suzanne Morphew investigation prior to becoming a district attorney on January 12, 2021. 9, the respondent met with law enforcement regarding the ongoing Morphew investigation on January 22, 2021, a meeting that included Alex Walker. From 2007 to spring 2001, Alex Walker was chief investigator for the DA's office. He continued in the position when the respondent was elected. In May 2021, Walker left the DA's office and moved to Chaffee County Sheriff's Office, where he works today. So he is absolutely, seems like he couldn't work with her. If you read between the lines, or I'm adding that as pure speculation. I will try to tell you when I'm adding pure speculation to this. Joseph Cahill, who was a former CBI agent, Robin Burgess, detective sergeant at Chaffee County Sheriff's Office, and Deputy District Attorney Jeff Lindsay. 10, as of January 2021, no charges had been filed related to Suzanne Morphew's disappearance. Suzanne Morphew's body was found on September 22, 2023. 11, respondent assigned Lindsay to be lead prosecutor on the Morphew investigation. 2, respondent also assigned Lindsay and the entire Chaffee County felony docket in addition to handling the Morphew investigation. 13, on April 30th and May 31st, 2021, Walker emailed respondent and DA Lindsay an amended draft affidavit for arrest warrant for Barry Morphew. 14, on May 5th, 2021, Walker submitted an affidavit in support of arrest to the court seeking a warrant with no bond hold of Barry Morphew for the first-degree murder of his wife, Suzanne Morphew. 15, Judge Patrick Murphy found that there was probable cause to arrest Barry Morphew and signed the arrest warrant the same day. Now, again, the arrest warrant, they are going on probable cause. It is not like they have to bring, 100% concrete proof. The judge just has to believe, okay, it is more likely that this person did this crime than not, and bring, more information to them, Now, respondent statements to the press and influencers started early and continue. 17, from April 2001 to August 2022, the respondent was in contact via text messaging with Mike King, host of Profiling Evil YouTube channel. That's a no-no. You, as a prosecutor, should not be talking to influencers. No. 18. Mike King is part of a global network of quote unquote true crime broadcasters, influencers, and his YouTube channel discussing true crime called Profiling Evil. 19. Respondent frequently updated King and responded to his requests for information about the Morphew case. That's a no no. And you know they have what is called receipts, ma'am. They can download your phone. You'd think a judge would be aware that, investigating bodies can take your phone, do that Cellbrite stuff, unless you live in Canton where phones are possessed by Satan and butt dial themselves, as they do. But this is not Canton. So she had to be vaguely aware that, they can look at your phone if they feel like shenanigans are afoot. Now, 21, on May 5th, 2021, the same day Walker submitted an arrest affidavit to the court for Morphew's arrest, respondent attended a press conference along with Sheriff John Spees. 22, in response to a question about whether Morphew was cooperating with the investigation and whether Morphew was asked if he knew where the body was, the respondent told the media he was taken into custody. When asked questions, he said he wanted a lawyer and all questioning ended. Smart man. Barry, I don't know you. I don't know if you're a sleazy McSleazerton, since I haven't really gotten into this case. But finally, a person who exercises and is able to exercise his Fifth Amendment. 23. On May 15th, 2021, when Mike King of Profiling Evil texted the respondent asking her for more information about the short force multiplier that Barry Morphew allegedly used to unalive Suzanne Morphew, as had been identified in the complaint, replied with, I'll see what I can do, only because it's you, Mike. Did you put emojis in there? I have a feeling there was a kiss emoji or like a little winky face, but maybe they didn't add the emojis. 24, when King texted the respondent and asked her if perhaps Mr. Morphew had strangled Suzanne in the hot tub, the respondent replied, quote, we know it wasn't bloody. The hot tub was drained with crust around the drain areas, indicating it had not been used in a long time, but keep on spinning ideas in your brain, end quote. She's a prosecutor. Y'all voted for her in Colorado. I feel like we need a full phone Cellbrite of everybody running for or for any sort of political office, because I feel like the American people are entitled to know how many backroom deals are going on. So I feel like, probably no one would run for elected office and we could replace the government with puppies, which I think might be cool and more efficient. Anywho, tangent unengaged. Let's get back. But yeah, maybe don't ask YouTubers who, look, if a prosecutor asked me what I thought, I'd be like, I'm a deeply unserious person that dyes their hair crazy colors. You want my opinion? Okay. I mean, I'm glad to give you my opinion. I have a lot of them, but maybe this is bad. 25. When King texted respondent and asked her about Suzanne Morphew's car keys, the respondent replied, quote, we think she always left her purse in her car, end quote. 26. In June 2021, when King texted respondent to comment about a new video on Barry Morphew, respondent replied, quote, I'm great, thanks. We got him, no worries. Oh, she did 2 exclamation points. Aw. She's so sighted. Maybe you should have focused on your case, ma'am, if you really thought you got the guy, but you didn't. And he got away. He walked away. Meanwhile, the prosecution struggles with its discovery obligations. Wait, a state prosecutor struggling to give over exculpatory discovery? I think I need to call, Nick McClelland from the Delphi case and say, don't worry, all prosecutors struggle with defense discovery. But ching. One second. Okay, sorry. Okay, we can, you know what? Congress will be cat and Senate will be dog, or other way around. But they'll have their own house. And reptiles can get Well, the state intelligence agencies, because I'll believe they're all snakes. I'm on the list now. Okay. 27. Within the first few months after Morphew's arrest, respondent was made aware by Lindsay and other staff at her office that they were having an extreme difficulty complying with Crime P16 mandatory disclosures in a timely manner in the Morphew case. 27. Respondent was aware that the Celia office, Chaffee County, did not have enough bandwidth to send defense counsel large amounts of electronic data, discovery videos, and photos via the Action 5 system in a timely manner. Okay, and the footnote is Action is a relatively robust computer program that allows prosecution to manage and track its cases, allow for note taking, allows for tasks to be sent and completed, allows for the filing of documents into the Colorado e-filing system, accessing discovery, Bates numbering, and more importantly, allows for the transmission of discovery through the Colorado District Attorney Council e-discovery system to defense. How does your emotional support alligator feel about walking me to all of my events on a leash, of course? Because I am still running for president. I want CNN to have to call me, and my mom will probably disown me for causing shenanigans, but I need at least 12 people to vote for me so CNN can say, and somewhat a bunch of people wrote in, mow in the deep end, hand jobs for all. We would like to figure this out. Can you imagine Wolf Blitzer talking to me? Well, this is a serious event. Why are you running for president? I was like, because hand jobs? But what I mean is vocational jobs. If you listen to my rhetoric, I'd give Wolf Blitzer a heart attack, let's be honest. Okay, 29. Morphew's defense counsel filed a motion to compel and for sanctions because the prosecution failed to timely disclose all information to Morphew as required by crime. So basically, about their discovery, procedures, they failed to get those in on time. 30. On June 3rd, 2001, Judge Murphy issued an order in response to the defendant's discovery motion declaring defense request for all email text messages between law enforcement officers and all individuals, including prosecutors, contacted and pertaining to this case is too broad and is not required by case law or statute. Therefore, it is ordered that any electronic communications created or received by law enforcement officers related to this case must be disclosed to the defense if they are material to the prosecution case or if they contain any evidence that would in any way be favorable to the defense. Now, 31. On July 20th, 2021, the prosecution disclosed a May 19th, 2001 CODIS DNA caseword match letter containing potentially exculpatory information, which the prosecution had in its possession for 2 months prior to disclosure. I'm noticing a trend here. Prosecutors aren't turning over exculpatory evidence. 32. On July 22nd, 2021, after another hearing on discovery issues, Judge Murphy determined the prosecution had violated discovery rules by failing to timely provide cell phone data and other electronic discovery to the defense, and ordered further production from the prosecution within 7 days. 33. Between July 22nd and August 2nd, 2021, prosecution disclosed a significant amount of information to the defense, including 1, a Tempe CODIS match letter dated 10/22/20, 2, a Phoenix CODIS match letter dated 11/19/20, and 3, a CODIS match in Illinois dated 4/28/21. Now, I know that people have strong opinions on this case, but if we have CODIS matches in several different states, this sounds like a serial offender and not the husband, unless the husband was also in all of those places. But this is just my first viewing. Like I said, we're going to get into the case. We're going to look at it closely. But if there were three different hits on several different states' CODIS, databanks, and CODIS is the, I want to say, Criminal Offender DNA Database or something. It's an acronym, but it's the DNA database. Generally, if you are convicted of a crime, you are forced, at least a felony, you're forced to give your DNA to go in the data bank. But also, unknown samples, victim samples, crime samples are also put in this database to see if maybe they get hits. Now, 34, in August 21, Lindsay contacted Dan Edwards, 6. Edwards had been practicing criminal law for 47 years, has a PD, a DA, and was assisting the attorney general. So she called, the guy who's supposed to know things, who at the time was not employed by the district attorney's office to assist with motions practice in the prosecution of Barry Morphew. 35. Sheriff Space was able to obtain help on the Morphew prosecution by obtaining $100,000 from the Chaffee County Commissioners. 36. The funds obtained by the sheriff could support hiring additional personnel, so Mark Hurlbert was hired as an additional deputy district attorney, and he began assisting on the case August 4th, 2021. 37. Morphew's combined preliminary hearing and presumption presumption great PEPG hearing was sentenced for was set for August 9th through the 10th and the 24th through the 25th, 2021. 38. On August 9th and 10th, 2021, the first 2 days of Morphew's combined PH and PEPG hearing, the defense identified a May 19th, 2021 CODIS DNA casework match letter regarding DNA swabbed from Miss Morphew's Range Rover, which partially matched an unknown suspect who had been investigated for SA. 39, defense questioned Walker about the letter extensively on cross-examination. 40, although prosecutors in the respondent's office had the May 19th, 2021 CODIS DNA casework match letter containing potentially exculpatory information in their possession, the letter was not disclosed to the defense until 2 months later on July 20th, only 20 days before this preliminary hearing, because they are a-holes. Respondent goes on profiling evil show after the PEPG hearing. Of course she does. 41. On August 24th, 25th, 2021, the last 2 days of the PEPG hearing, defense cross-examined former CBI agent Cahill regarding the CODIS DNA casework match letter. 42. On August 24th at 10:31 a.m. during the third day of the PEPG hearing, Mike King texted the respondent the question, quote, "Feeling good?" end quote, with a little question mark. The respondent replied, "Yes, only because the judge has basically indicated he's done. That's good for us," end quote. It gets better because she decides to do oppo research on the judge when he starts, ruling in the case of justice and not in the case of this chick. 44. On August 29th, King and the respondent discussed via text message and phone what King would say to his audience about the Morphew case and what King would say to his audience about the respondents. On 45, on August 30th, 2021, respondent appeared on Mike King's YouTube channel called Profiling Evil, a publicly viewable show and comment forum to discuss Barry Morphew's case. Well, I mean, it's better than being asked by Chris Hansen to take a seat with your Subway sandwich and your, bag of, love gloves. I mean, it could be worse, but you went on a YouTube You went on a YouTube channel, ma'am. I mean, not even Ursula. I mean, Nancy Grace. You didn't go on again, and I am not disparaging YouTube channels. I think that some of them do great. But the fact that the actual, district attorney is talking and giving inside information to a YouTuber is beyond the pale. And then going on there, I mean, this woman was like, "How do I torpedo this case from Mars?" I mean, she understood the assignment of making this case go bye-bye. But here you go. Yeah, again, she discussed this case. Well, yeah, pretty much. 46. During or after the Profiling Evil podcast, respondent also made written statements in the online comments section after the podcast ended. Wow, I see a career for you being Coffin Digger's, you know, best friend. Oh my God, if you two did a podcast, the disgraced DA and the chick who swept floors at the FBI. And y'all, I respect most women in any kind of first responder, but Coffin Dingleberry, no, no, just no. But if the two of them had a podcast, oh my gosh, if we got the trifecta of Ursula, I mean Nancy Grace, Coffin Donger, and this chick, could you imagine the nexus of, well, just harpy that would create in the universe? They would open a black hole of bitchiness and we would be sucked into it. So actually, the three of them can never be in the same place at the same time. Let's see, 47. In addition to commenting immediately after the podcast, the respondent used her own name as her username. Ma'am, you didn't even go like undercover DA. Seriously, for the love of Cheetos. And authored numerous other comments in response to various members of the public who had also written comments to Profiling Evil. Oh, she's a reply gal. I see this. 48. A commenter on YouTube with the username Jean Luc Barcer posted the following on Profiling Evil in response to the respondent's statements about Morphew. In preliminary hearing, you're supposed to lay out enough evidence to take the accused to trial. The defense did a great job of debunking a few of the theories. Most reasonable observers of this case aren't even confident that the state laid out enough evidence to take this to trial. How do you expect them to win a case with zero DNA and zero body with a very weak preliminary hearing? If there was some smoking gun, they could have provided more info at the preliminary hearing, causing the judge to actually send it to trial on day 4. Him needing time is not a sign of a very strong case. He has read the holy something removed affidavit already. So if you think that there is something special in there, think again. It's best for the state to let this one go for now. Try them again if you have better evidence. She couldn't let that stand. No, hell, she couldn't. She's a strong girl boss DA who's getting made fun of on the internet. So her Karen came out. In response to this comment, respondent, again using her own name as her username, wrote, "The judge explained why he's going to take time with it. He actually should because there's a lot of evidence admitted. I'm curious how long you've been a criminal law attorney since you like to think that you know that. Look this up. Dante Lucas convicted in Pueblo, Colorado, right next to my jurisdiction, less than a year ago for first-degree murder. Double exclamation points. Guess what? No DNA, no body, no murder weapon, no smoking gun, as you say. But here's the clincher. He was the last person to see Kelsey alive. Wait a minute. So you, a champion of justice, are supposed are really proud that you sent a man to jail because he was the last person to see someone alive. No evidence, absolutely no physical evidence, no DNA, no body, no murder weapon, no smoking gun. And you are proud that you send this man to the clink? I mean, unless he confessed, this is absolute someone needs to look into that case. In fact, let me, write it down on my handy dandy my handy dandy Post-it pass pad, because we will be looking in that case in conjunction with this case to see how the hell this man got convicted. Um, I mean, they might have a bunch of circumstantial stuff like he saw her last, his car tires match other things, but the fact that she is again trying to do the sassy clapback, basically saying we, put a man in with no evidence, makes me kind of irritated and scared. And Barry was the last one to see Suzanne alive. As we stated in the prelim, yes, he might have been the last one, that has admitted to seeing her alive. That doesn't mean that someone else didn't cross her path. Those items you listed might be important to you, but not for others. Uh, Parentheses, P.S. Dylan Renwine's father also was recently convicted of first degree murder in the death of his son. Same scenario. Didn't have a laundry list of items that you think are required for conviction. I can come up with plenty more. Just let me know. Okay, ma'am, the Daniel Redwine case. He was seen where the body was eventually found. There was his son's blood, and DNA evidence in his trailer, regardless of him getting new carpet. It would seeped into, I guess, the subflooring. He was the last person to see him, but we have evidence that, Dylan Redwine found out that his dad liked to dress up in ladies' clothing and eat poo. He was a coprophiliac. And I'm guessing that, things went wrong, but there was a lot of evidence. There was a lot of things that, corroborated, not DNA per se, but there were a lot of pieces that you could put together that show that Dylan Redwine's father, Daniel Redwine, was the only person that was supposed to that could have had the means and opportunity to do this. And ma'am, I'm gonna go full Will Smith, but keep Dylan Redwine's name out your mouth. A slimy prosecutor like you deserves to have nothing included near, a case that actually involved justice. But I'm sure you felt really smart as you were replying to this, rando person on the internet. And ma'am, the fact that you have a law degree and you screwed the pooch so much that you're disbarred, I don't think you should be using, the fallacy of authority to go after someone who is maybe commenting on the internet. I don't have a law degree, doesn't stop me from judging this chick, but I don't revert to authority. Oh, the Dylan Redwine case is actually very sad. We're tangenting now, so let me get this going. Okay, welcome, Wise Angel UK. So, a too long didn't read of the Daniel Redwine case, where unfortunately his son Dylan Redwine was most probably, and if you look at all of the evidence, unalived by his father. Um, Several months before the Thanksgiving break, I guess Dylan found on his father's laptop some very personal photos of his father dressed in makeup, wearing baby clothes and women's lingerie, eating from an adult diaper. That is as far as I'm going. There are pictures out there. I do not recommend. Now, naturally, Dylan found this gross, disgusting, and just horrible and never wanted to see his father again. But unfortunately, due to child custody arrangements and Dylan not being, I believe, 13, he was not allowed to skip parenting time with his father. He had begged his mother not to go on Thanksgiving. He didn't want to go. He had lost all respect for his father. And he was in a bad mood. I'm guessing he was a typical 12-year-old who didn't want to be somewhere and smarted off And when, he smarted off to his dad and said, "I don't respect you, you eat your own poo," or something along that lines. It looks like unfortunately, they didn't find Dylan's body until it was fully skeletonized, but, there was a deep depression in his head that looked like he was the victim of blunt force trauma on his head. Now, Daniel's defense did try to say that he was attacked by a bear, but that kind of got dropped down because bears don't typically hibernating at that time, and none of his other bones, had the sort of, it did look like there was some animal activity, but there wasn't, like any sort of bite marks on his head that would indicate that this was a bear, mostly because it wasn't possible. But it was a case where he was, um, initially charged with abduction and child neglect or child harm, I believe. It wasn't until the body was found years later, in a place where he was seen riding his four-wheeler, going up there, messing with things as people were searching. So there is a lot more evidence that Daniel Redwine unalived his son than there is for, this case, as far as I can see. 50. On September 14th, 2021, the respondent exchanged Facebook Messenger message with Jules Wolfe, creator of True Crime with Jules, which is a podcast available through YouTube and other public forums regarding Barry Morphew. 51. When Wolfe asked whether Morphew was getting ready to flee, the respondent said, quote unquote, possibly. It's bad when, and I don't know what I classify myself as. I call myself a lay tuber because it's a single entendre. But if I were truly to go into the true crime, I would never accept any help from a prosecutor. I would never contact a prosecutor because that just seems creepy and gross. That seems gross on an ethics sort of side, that she's sharing this detailed information and really shaping the public narrative through these influencers, through these true crimers. And shame on you, true crimers, for again spreading a message from the state. 52. These text messages were made public by Wolfe and remained available to the public to read. 53. On September 16th, 2021, Morphew's defense filed a motion for sanctions for violation of the court's pretrial publicity order of June 3rd, 2021. 54. The motion was based in part on the respondent's statements to media and the respondent's written comments to the public on Profiling Evil YouTube channel and to Jules Wolfe, the creator of True Crime with Jules. Yeah, I would love to do a deep dive into Lucy Letby's case, but there isn't any filming in UK courts, and I am not sure how to get all the documentation. And that case is heartbreaking, and I don't know. Having children and children that have been in the NICU, my heart goes out to her victims, and really, what a jerk. Allegedly, because I know she is filing an appeal. But she has been adjudicated guilty for the time being. 55. On September 17th, 2021, the court found that there was probable cause for the charges against Morphew, but that the prosecution did not meet its burden regarding the proof evident presumption greater portion of the hearing. 56. The defense requested a $50,000 bond. And thank you, Antique, for gifting one membership. And that went to Nanny Goat. Congratulations and welcome to the Church of Mo. We enjoy dark chocolate and sarcasm. Excuse me. But please, no plastic recorders or overdosing on patchouli oil. I just can't smell. Look, patchouli oil lightly. It does not replace deodorant. It is a Church of Mo commandment. Thank you so much. These are going up on the board. Um, 1 second. Okie dokie, slight change in plans. I guess middle daughter slept in this morning, and well, we were. I need to run her to school. So let me find if Court TV or has some attorney or has some stories we can watch while I have to run her in because it's about 10 minutes away. So I'm trying to find something that will not get me struck immediately, as you know, because people are jerk faces when it comes to copyright. Alrighty. So I will put on, it looks like Barry Morphew is suing the state. I can't imagine why. But we can watch a little bit of this while I run her to school. Thank you for being understanding. Mom duties always come in at sometimes the worst.
For the Morphew family never happened. That's because Suzanne was reported missing by a neighbor after no one could contact her. The search for Suzanne was immediate but unsuccessful. Then as the months went by, suspicion grew around Barry. He was arrested and charged with her murder, and more details were revealed. A mysterious tranquilizer dart cap was found in the laundry. Barry was seen dumping trash bags all over Broomfield, and Suzanne's affair with an old friend was revealed. But then just before his murder trial, prosecutors dropped the charges against Barry. He was set free. Then the skeletal remains of Suzanne were found about 50 minutes south of the Morphew's home. Barry and his attorneys insist this is proof of his innocence, and they are getting ready to go back to court not as a defendant but as a plaintiff, suing the investigators and prosecutors for violating his civil rights. Tonight we take a closer look at all these shocking developments connected to the murder of Suzanne Morphew.
I'm Vinny Politan. Thank you so much for joining us here on Closing Arguments. Suzanne Morphew went missing. That's how this story began. It's a missing mom on Mother's Day. Where did she go? Where was her family? Well, apparently no one was home. They were going to get together that night, but she was missing. They couldn't contact her, couldn't find her, and this search began very quickly in this case. And as it began, there were questions and there were suspicions, the normal suspicions that happen in all these cases where a loved one, either a child or a spouse, a boyfriend, a girlfriend go missing. And you know where the circle starts with those closest to the missing person and it sort of expands. But what exactly happened here? Well, as the investigation continued, they still didn't find Suzanne, but they charged her husband, Barry. They charged him for murder. They locked him up, he was detained, and everything was moving forward towards a trial. It was a case that we were tracking and we were following every development, anticipating that trial to happen. Then just a few days before the trial happens, and by the way, it wasn't going to be an easy case. It was going to be a tough case, but it seemed from what they were alleging, prosecutors had some compelling information, some compelling evidence that they believed could prove the case. But then just a few days before it started, they dropped the charges. and Barry was set free. You see him here with his daughters. His daughters support him 1,000%. They do not believe that their father had anything to do with their mother going missing. So when he was set free, the prosecutor said, well, you know, this will be a stronger case if we recover Suzanne's remains. And there were also some issues with prosecutors not handing over certain materials or revealing certain materials in the case. And the judge wasn't happy with that. So there were problems on two fronts in the case. The charges were dropped, but they could always be brought again because there was no jury. Jeopardy had not attached, not a situation of double jeopardy. He can still be charged with murder. So then last fall, her remains are recovered. They find Suzanne. And all of a sudden, everyone starts looking, okay, what can you get from the autopsy? What can you figure out? What can you prove? Where was she found? Where was Barry? You know, so you had to put all those pieces together, and then sort of sitting in this limbo where nothing's happening. Suzanne is found, but there's no charges coming against Barry Morphew, and everyone's wondering what's going to happen, what's going to be the next shoe to drop. Well, the next shoe to drop was another court case. Not a criminal case against Barry, but a civil case by Barry. He's now suing the prosecution, the investigators, going after them for a whole lot of money for violating his civil rights. Take a look. As a proximate result of defendants, meaning all these investigators and the prosecutor, unlawful conduct, Barry Morphew was arrested, held in custody until he was able to bond out, and lived under bond conditions for over 11 months and suffered severe actual physical and emotional injuries and other damages and losses. Damages to date are estimated to be $15 million. So this is now a big lawsuit. And this is a big deal. When you sue somebody, you get deposed. Are you following this? When you sue somebody, you get deposed. Meaning if this civil suit continues, at some point the government will be able to sit down with Barry Morphew and question him under oath about this case. So it's a big gutsy move. Now, if you're factually innocent, it's the right move. If you did it, it is really dangerous. Now, I'm getting a little bit ahead of myself. For those of you who don't remember the details in this case, Matt Johnson, Court TV crime and justice correspondent, has them for us tonight.
Where is it? Where's the bike? Oh, it's right there. Where was it? It was like just right down here in this little embankment.
8:46 p.m. Sunday, May 10th, 2020. 53-year-old Barry Morphew arrives at the scene where his wife, Suzanne Morphew's bike and helmet were found about a mile from their house by police. It was Mother's Day, but her daughters were away on a camping trip, and Barry told police that he had spent the day working on a job north of Denver in Broomfield, Colorado.
Just for confirmation, you left this morning at 5. Okay. And she told you she was going to go bike riding?
Bikes every day.
At around 5 p.m., a neighbor called 911 after checking Suzanne's house and telling Barry she couldn't contact her friend.
So the last time you probably actually saw her was this morning. That was it, right?
Yeah, I've been here, so I got a big job up there. I've been here all day.
Barry owned a landscaping business, and Suzanne was a stay-at-home mother who was being treated for cancer. The couple lived in Maysville, Colorado, about 2.5 hours southwest of Denver.
Is it a crash?
I mean, the bike looked, the way it was laid, it kind of looked like it, but there's not really that much damage to the bike. That's the thing.
Lion?
Yeah, it was a lion.
No lion?
I didn't see anything that was...
Suzanne's disappearance quickly became a missing persons case. Her brother helped organize and lead searches for her with no success.
Unfortunately, every time the dogs hit on a scent, it seems to be close to or around one of his properties. What that might indicate is that scent was on his bobcat, and everywhere he used it, we're running into it.
Barry didn't participate in those searches, but he did post a plea for Suzanne's return on YouTube.
Oh, Suzanne, if anyone is out there that can hear this, that has you, please, we'll do whatever it takes to bring you back.
On May 5th, 2021, almost a year after she vanished, Suzanne's husband Barry was arrested and charged with her murder.
The investigation is still ongoing. Suzanne, her body has not been found, and we're still looking into that.
According to the arrest affidavit, the Morphew's marriage was falling apart. She was having an affair and believed that he was cheating too. The week before she disappeared, she texted him that she was done with him, and they had to resolve their situation civilly. They also had a history of fights over money, and he was pressuring Suzanne to loan him thousands of dollars. But in the spring of 2022, days before his scheduled trial, prosecutors dropped Barry's charges without prejudice. The judge had thrown out the potential testimony of several key witnesses because of alleged discovery violations. And without Suzanne's body, prosecutors said they could not move forward with the trial.
Barry and his daughters are relieved, but they're sad because they too want to know where Suzanne Morphew is.
In May 2023, a year after the charges were dismissed, Barry Morphew filed a $15 million suit against the investigators into his wife's disappearance and the district attorney in the case. He and his daughter sat down with Good Morning America to discuss the possibility of future charges.
Well, I was innocent the first time they arrested me, so I'm sure it's possible. But I don't have anything to worry about. I've done nothing wrong.
More than 3 years after Suzanne Morphew went missing, investigators found her remains in a shallow grave. Police discovered her while investigating an unrelated missing persons case. The site? A desert field of sagebrush near Moffett, a town 45 miles south of Suzanne and Barry's home in Maysville, not part of the original search locations. Barry Morphew's attorney said that he and his daughters were shocked by the news of her discovery and point to the fact that there is no GPS or cell phone evidence that places Barry near Moffett the weekend Suzanne disappeared.
And joining me, former homicide detective and host of The Interview Room with Chris McDonough. Chris McDonough is with us. Chris, great to see you. Thanks so much. I know you've spent a lot of time taking a look at this case. Let's start here. As you look at the way everything progressed, all the different twists and turns in this case, are you surprised that we're sitting here tonight and it's Barry Morphew who's going after prosecutors and not prosecutors going after Barry Morphew?
It's great seeing you, Vinny. And, just to kind of kick this off no, I'm not surprised that he's going to continue on the path that he's on. That is a very risky proposition based on what you had mentioned earlier. I think one of the things that the public needs to remember, to your point about a civil lawsuit, it's much different than a criminal lawsuit. Miranda is not necessary, and every single person that he sues gets an attorney. That means every single one of those attorneys gets another shot at Barry Morphew in terms of an interview. So, that's kind of risky in of itself. So I guess kind of in a way, I am surprised that we're sitting here, but not completely.
And what's interesting, a lot of times in these cases, the civil complaint is going the other way. It's going against the person who was at one time accused of the murder, and it's usually like a wrongful death situation. That's not here. This is the complete reverse. I want to put up a piece of the civil complaint because this I found fascinating. Barry Morphew alleging on May 19th, 2021, defendant CBI agent Duge sent a CODIS match letter via email indicating the unknown male DNA swabbed from the glove box of Suzanne's Range Rover partially matched DNA found in three out of state unsolved sexual assault investigations in Tempe, Phoenix, and Chicago. None of the defendants with knowledge of the three DNA matches and the unknown DNA intervened to ensure that this exculpatory DNA information was included in the arrest affidavit before it was presented to the court. But I want to get your take as homicide detective, Chris. You've got DNA from the glove box of her vehicle matching someone who's been committing sexual assaults in Tempe, Phoenix, and Chicago. What do you think of that?
Well, that's a great point, Vinny. But so let's think of, right, the defense here is Saad, some other dude. However, here's the problem with that. If those are your perpetrators, then it sounds like they, A, kidnapped her in that vehicle potentially, dropped her off, and then drove the car back and parked it back in the garage and left their DNA. Okay, so that in of itself, try to sort through that is kind of problematic. I would suspect for Barry Morphew, because if it's a partial DNA and it's not 100% match, well, that's the other piece. The other thing he has to think about is the glove that's recovered at the crime scene in where Suzanne was buried. What's in that glove? We don't know yet. What's in the clothing that was recovered at Suzanne's gravesite? So he's got to take that into consideration as well.
Another part of the civil complaint, again, Barry Morphew suing the people who were prosecuting him and investigating him. The arrest warrant affidavit states that Barry chased Suzanne Morphew around their home. The arrest affidavit includes attachment 6, an estimate of the activity of Barry's phone as it appears to move from porch to porch, which Barry, explained by chasing and shooting a chipmunk. On June 2nd, 2020, defendants Cahill and Grusing, who are investigators in the case, learned from the FBI Special Agent Hoyland that data used to pinpoint Barry's movements was unreliable. Here's what Special Agent Hoyland wrote. For your information, one of the challenges in determining movement with the GPS readings in such a tight area is that there's a phenomenon known as static drift, wherein a stationary device can mistakenly be shown to be moving because of the number of satellites taking measurements and their corresponding locations to the stationary device. Or it could be him walking around the property, just hard to say. But I would be cautious in jumping right to the conclusion that he was bouncing around the property at these hours. So what are your thoughts there? Because a big part of their theory was he was chasing her, right? He was chasing Suzanne. He said something, maybe I was chasing a chipmunk. But the FBI special agent is saying, well, this is unreliable GPS data.
Yeah, and you know more than anybody, Vinny. I mean, you've been in the courtroom hundreds of times, I'm sure of it, with, on homicide trials. One of the things that is always important to understand is the first GPS or the first cell phone tower dumps that they get is just the very first layer of the cake. There are secondary layers of that cake from, I'll give you one of the companies that the FBI uses is a company called Gladiator Forensics. And that Gladiator Forensics company is able to pinpoint that data even further, deeper into that cake in of itself. So I wouldn't get too worried about that personally as an investigator, because I would suspect that's just the top of the layer of the cake and not necessarily the totality of making the cake.
All right, one more part of this civil complaint I need to get your thoughts on. In the arrest affidavit, the defendant stated that Barry's truck drove nearby where Suzanne's bicycle helmet was later discovered. Defendant Cahill received a recommendation from a technical engineering firm that even though inaccurate and unreliable, the GPS location data could be used to squeeze Barry during interrogations. Defendant Cahill forwarded this recommendation to one of the investigators. Joe, you would need to be careful with this, as the confidence of this particular location estimate for Barry's phone is low, and there are real considerations about its accuracy. However, in an interrogation, this could be very powerful in potentially squeezing Barry. Well, Barry never got squeezed. He never admitted to anything, but they used this information in the arrest affidavit. And that seems to be a problem, according to Barry and his attorneys.
Yeah, well, remember, Vinny, they asked him, well, how can you explain your the ping down here? And his excuse, remember, was he was tracking a moose in that same direction. And so to your point, I don't think they've had a second shot at him to really sit down. But again, the civil suit may give about 50 attorneys that second shot.
And I can see how they were going to use those statements against him, right? He's chasing chipmunks. He's tracking a moose, right? And you start to think, all right, what's going on here? What exactly is going on here? So as we sit here tonight, do you expect, or do you think that prosecutors need something more to give it a second go around against Barry Morphew? Because he's saying he's 100% innocent.
There's always, you never investigate the person, right? You always investigate the information. And if there's exculpatory information that's presenting itself on the second round here, then by all means, the investigators need to go down that lane. The problem that we have here, though, that I think is a high hurdle for him is the fact that, Suzanne returned in 3 separate bags to the ME's office, and the chemical used to take her down just happened to be the exact same chemical he uses. And you tie that together with all the other circumstantial evidence, it's going to be quite the run in court.
Absolutely, but there were some problems that the prosecutor had in handing things over. Chris McDonough, thank you. We're going to see you in our second hour. You're going to be working some overtime for us tonight. You can put in for it at the end of the show. Thanks so much, Chris. When we come back, we'll bring in our think tank, get their take on this latest twist and turn in the Barry Suzanne Morphew case. Plus, coming up next hour.
Tonight on Vinnie Politan Investigates, 15-year-old Sebastian Rogers has been missing since February 26th. Tonight, his father joins us live for all the latest in the search for his son.
Join Court TV's Vinnie Politan.
In every story, in every trial, every case, there's at least 2 sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside, I've never seen that in Discovery. I've been incarcerated 3 years.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central. Only on Court TV.
It was weird because it feels like the top of the bike was like up this way.
So maybe flipped.
Maybe, I don't know, man.
But just call this.
Go ahead.
What's the thing about 4 o'clock in the morning? Or is that 30 on the phone?
5. Oh, yeah, so we pinged the phone and it said the last activity was at 4 in the morning.
Up here?
It's off of the Ponzi tag. So there's not any specific coordinate. Hey, could you not touch the bike with your hands, please?
Hey, guys.
That's how it goes.
So that's the body camera video from the day Suzanne Morphew went missing, and they found her bike like a mile from her home, and they found the helmet somewhere else. But that was, when this case first started, it's like, okay, she's missing, she took a bike ride, something happened. But they live in the middle of nowhere, like in the middle of nowhere. Like, it's doubtful there's going to be a hit and run or some crime of opportunity that's going to take place, like someone that just happens to be driving by. Like, you're in the middle of nowhere. So it was always sort of suspicious what happened here. So let's take a look, though, at the timeline, because I think it gives you a little more insight into how all of this developed in the case. May 9th, 2020, Suzanne Morphew's last known communication is a selfie, here you go, sent to her lover in Michigan. She did not respond to his reply messages. You could read into that what you want. May 10th, Barry says Suzanne was still sleeping when he left for business in Broomfield, Colorado. He is seen on surveillance at a Broomfield Holiday Inn with 2 white trash bags that morning. Barry is seen on surveillance video placing items into trash cans around Broomfield, Colorado. Why? May 10th, later that day, Suzanne is reported missing. Then Suzanne's bicycle is found near their home down a steep ravine off Chaffee County Road 225 from Highway 50. Some people are wondering, was it like an animal attack, a mountain lion or something? May 11th, search efforts begin. Hundreds of people work to find Suzanne. A reward for information grows. May 13th, Suzanne's bike helmet is found less than a mile from where her bicycle was located. Strange fact. May 17th, Barry Morphew posts a video online pleading for Suzanne's safe return. May 20th, investigators locate a spy pen during the search of the Morphew's residence. In one file, Suzanne apparently places the pen in Barry's car, where it records him listening to multiple episodes of Forensic Files. Nothing wrong with that, by the way. May 5th, 2021, Barry is arrested, charged with first-degree murder and other crimes. April 19th, 2022, days before the trial set to begin, prosecutors dropped the charges without prejudice. September 22, 2023, Suzanne's remains are found in an unrelated search. And then September 27th, the remains are positively identified. Now, Barry is suing investigators and
all righty, we are back. Thank you for letting me run away and join the circus, or as I like to call it, the mom taxi. And just a public service announcement out there. If you have littles like toddlers, school-age children, hold tightly in your heart when they say, "Mommy, I love you. You're my favoritist person," because they will become surly teens that when you ask them, "Hey, I'm not a mind reader, but it seems like something's bothering you, and I'm not forcing you to talk to me right now, but if you'd like to talk, I'm here." When you're trying to be all emotionally available and all the stuff that maybe you thought your mom wasn't great at, so you try to work a little bit on being emotionally available and not judgmental, and you get back, "I am fine." Again, hold those toddlers, "I love you, mommy, you're my favorite person," close to your heart, because they will become teens that look at you like you're the dumbest person in the entire universe. Anyhoozle, it was nice to be able to listen to not Vinnie Politain. I mean, although he's better than that one guy who looks like a Ken doll from Law and Crime. So, he is better, but that does give me an overview of why people maybe suspected Barry more. So it does give me some ideas that challenge my, yes, there's probably prosecutorial misconduct, but there might be more going on in this case. Now, I will say that I will ask the question that maybe is a dumb question because, I'm not a lawyer. But if you don't know the answers to what DNA is on the glove, you don't know the answers to what the clothing was, why did you bring the case? And I understand that this is years past them, finding her body. He hasn't been charged, but you're going to tell me that testing still hasn't been done? It just, it boggles the mind. It does. Okay, let's see here. So the prosecution requested a $10 million bond, and ultimately the court set a $500,000 cash bond for Barry. 58, Judge Murphy stated he had not reviewed the defense motion, but advised respondent, "While I won't order it, it certainly seems reasonable to limit interaction and interviews with the media regarding a specific case that you're prosecuting. That is the normal route I see most prosecutors take. So I'm not ruling on the motion. I'm not issuing an order other than the order I've already issued. But I am saying if there's a violation, it's going to be a self-inflicted wound." So he is gently as lawyers can or judges can, telling the prosecution to stop screwing around. Stop doing these interviews, stop going on YouTube to, litigate this crime. Also, public service announcement, I got these little cans of Oreo Coca-Cola for the kids to try because they like trying all the new special flavors. Not good. I don't know who decided Oreos and Coke belong together, but that's a no-go. Also, the Oreos are gross too, in my son's opinion, though he did manage to lick the cream filling out of every single one of the really gross Oreos. So I don't know how honest he was. I go in to try one. There are literally just the sandwich cookies and no cream filling in all of them. Just like, okay. So there you go, public service announcement. We only live about 5 to 7 minutes away from the school, depending on the world's longest red lights. So it is kind of nice that I can just pop over and get them to school and then not really miss things, because momming is a full-time job and I have 6 children, and I'm sure I'm going to be running to get a poster board for an unfinished project sometime this week. Anyhoozle. 59. Later, when King from Profiling Evil texted respondent's question about the hearing, respondent replied to his text, quote, "No surprise, or not surprised on bail, no CH, and our CBI witness, K. Hill, majorly screwed up on his testimony, and he's not on the case anymore." So I guess the people that had their testimony excused or removed because of discovery issues, it was their fault. Ugh, that doesn't sound good at all. The frozen icy drinks. Yeah, I don't get it. No, with no additional funding requested, the prosecution team struggled with staffing. 60. The respondent did not ask for additional funding for the Morphew prosecution when she submitted her 2022 budget to the commissioners in September 2021, reasoning that to do so would, quote, "take a lot of time away from us to have a public meeting in front of all the commissioners," brackets, "and the commissioners would argue, why are we paying more for your entire budget when this is over in May? And if it doesn't go, for whatever reason it doesn't go, they're going to ask for that money back, etc." Well, I mean, yeah, why ask for extra funding for a large case that has, a bunch of electronic data and, DNA data? Nah, it'll be fine. It'll be fine. 61. Lindsay resigned in October 2021 and gave 4 weeks of notice. 62. Respondent assigned Hurlburt to take over as lead counsel on the Morphew case. 63. On October 29th, 2022, Lindsay left the 11th Judicial Office, and the respondent hired Bob Weiner to assist with them. Am I being punked here? Is this from The Onion? We have Hurlburt and Weiner. With their powers combined, super twins. This is the law office of Hurlburt and Weiner, or Weiner and Hurlburt. I would pick that law office, but that's because I'm a deeply unserious person. Court requires change of venue in part due to the respondent's extrajudicial statements. So basically, they had to ask for a change of venue because this chick, the prosecutor, was running her mouth everywhere. So she actually gave them a change of venue. It was a self-inflicted wound, as the judge said. On January 25th, 2022, the court held a hearing on the defense's motion for sanction for pretrial extrajudicial statements, which highlighted numerous statements by the respondent to the media, as well as the respondent's written comments to the public on Profiling Evil YouTube channel and Jules Wolfe, the creator of True Crime with Jules. 65. Judge Murphy recused himself because he was good friends with the lawyer representing Barry Morphew's new girlfriend, Shoshana Dark. 66. Judge Ramsey Lima was then assigned to preside over the case now in Fremont County, case 22CR 47. 67. Judge Lima reviewed numerous statements that the respondent had made publicly regarding Morphew, as well as an affidavit from a Salada community letter or member who attested that, quote, the talk of the town was that the media, the DA Stanley and the Judge Murphy had all made statements that convinced them that Barry Morphew killed his wife, end quote. 68. On January 31st, 2022, the court issued an order granting the motion to change venue based in part on the respondent's out-of-court statements. So again, it was self-inflicted. If they truly believed in their heart that this man is guilty, then why not wait for all of the evidence? He honestly didn't seem like he was going anywhere. You could have said, anything. You could have continued investigating. I'm guessing there was no red Solo cups when they found the bicycle because people were touching it without gloves. Did all of these people study with the Canton State Troopers asking for a friend, okay? Because evidence, no, touch it with your bare murder mittens. I'm sure that's a good idea. Just get all the DNA on there. Get some red Solo cups. It'll be fine. Respondent fails to ensure the prosecution team properly discloses its experts. 70. The respondent knew or should have known the Morphew case depended heavily on expert testimony, given there was no body to establish murder, and much of the typical forensic evidence in a homicide was not available, such that expert disclosure requirements needed to be met fully and on time. Well, she's got ADHD. She just got distracted by glitter, I'm sure. 71. Prosecution expert disclosures were due February 14th, 2022. 72. Edwards drafted the expert disclosures without having reviewed the discovery, pulling names only from the pleadings. Well, you know how as a mom or a parent or a birthing person, whatever I'm supposed to call y'all now. I don't know. I'm just calling you mom or dad or person that's in charge of young ones. We all know that the project that we help / complete fully at 7 or, from 9 p.m. to 3 a.m. is not going to be our best work. But darn it, we better get an A along with our child. Look, I have no shame. I have asked my son, like, so what did we get on our project? And he's like, well, we got a B. And I'm like, I am going. I've had the slight inclination to say, do you know how long we stayed up to do this? I believe we deserve an A, or I do, or an adult beverage pass. I mean, whichever you're going to give me. But, I'm like, but I worked my bestest on that. We got an A in my brain. 74. Neither the respondent or Hurlburt nor Wiener reviewed Edwards' expert disclosure for accuracy before it was filed. 75. No one from the prosecution team timely disclosed the CVs and expert reports of the prosecution's experts as required by the court's order. I love this. The prosecution's a teen, or Sarah Boone, like, you don't understand. I'm on honor roll. And as a prosecutor, I can never be held, accountable for anything. I'm a high achiever. 76. On February 24th, 2022, the court held a hearing on expert disclosures during which the prosecution conceded that their expert disclosures did not comply with Rule 16 or the court's case management order. Got to read that syllabus, got to read those instructions. That's how we got an almost A on our, about me poster board. 77. The prosecution sought and received an extension of time to February 28th, 2022 to supplement their expert disclosures. 78. On February 24th, 2022, Edwards filed his notice of withdrawal and left the prosecution team. Well, I'm sure the prosecutor is not a terrible person to work with. I'm sure people just quit because they're going to better pastures. That would be the second person that's quit and said, like, don't mention me on LinkedIn. 79. On February 28th, 2022, Hurlburt filed a P-44, People's Superseding Endorsement of Expert Witnesses, which admitted that some of the listed experts were still in the process of preparing a statement. 80. The prosecution's superseding expert disclosure filed February 28th, 2022, was still missing expert reports and CVs from various experts, which they were specifically required by the court's order to provide. 88. Respondent was aware that the defense filed multiple motions to exclude experts' opinions based on prosecution's failure to comply with the expert disclosure requirements. Now, is this by design, this incompetence? Or I guess my question is to you guys, because I'm trying to go into this with, yes, my snark, and I will make fun of everyone. Barry, you're not off the hook. And ma'am's lover, you're also not on the hook, or not off the hook. I am an equal opportunity snark assassin, let me tell you. I even snark myself. Believe me, I'm much meaner to me than I am to the general public. Anywho, at what point does incompetence and inability to make sure that your team does what they're supposed to rise to the level of Wise Angel, another mom that gets me. I'm glad I'm not the only one that was like, but we worked so hard on that. We made trading cards all about you. Why did we get an A? We even laminated it, damn it. I found the laminating machine. We were high class all the way. Well, Wise Angel, I give you an A because I would not know where to start on a handmade Gruffalo costume. I guess back to my train of thought, though. At what point does incompetence and inability to meet deadlines become, by design, become something that is more criminal than, just oops-a-daisy? Because at this point, they have failed to provide anything on time. To link it to another case that is having a real hard time with discovery, the Delphi case is dealing with this too. Now, in the Delphi case, we don't have a very cooperative judge, and she just kind of nukes everything that the defense puts in. But this discovery thing with prosecutors slow walking discovery is not a new thing. I am trying to get my friend Kara Winicky, she is an appellate lawyer in Indiana. She is very busy working on real cases, helping real people as I snark on the internet. But I do want to talk to her about kind of what real life lawyers deal with as far as getting discovery from the prosecution. Is this the rule that prosecutors slow walk discovery, or is this, simply something that we are seeing more of in maybe weaker but more high profile cases? Or is this a systemic problem that needs to be addressed? Because if it is a systemic problem, then nobody is getting the justice that I want my justice system to be. I guess before I started watching trials, I figured that our justice system was kind of okay, but now watching trials, watching things that the state does, there does seem to be room for some reform there. Now, I don't know how you do it. I am, again, not the world's smartest person, but I do think that it is something that needs to be exposed. If it is happening, if it is systemic and not sort of just a hit or miss thing. Now, 82. On March 1st, 2022, the defense filed a supplemental motion to strike witness proffered as expert and motion to strike, noting prejudice to the defense because the prosecution had still not included expert CVs or their resumes, that fun bit we get to do in every trial, like, well, how do you know what DNA is? And, I've been practicing as a doctor for so years. I'm accredited and, I have a board certification. All that jazz, that is supposed to be something that the state hands over so that the defense can get its own expert witnesses to counter or rebut some of the, explanations of the state. They did not do that. Dang it. Dang time. Time is just a social construct. I'm going to try that one day. 88 on March 2nd, 2022. It just, again, goes into the motion to strike experts. 84, Grant Grossberger joined the Morphew prosecution team. So wait a minute, because my ADHD brain cannot handle this. But we had the combined forces of Hurlburt, let's see here, Grossberger and Wiener as the dream team for the prosecution. I mean, I would watch that trial just for the names of the prosecutors. 85 on March 3rd, 2022, the prosecution provided additional discovery, including emails with law enforcement created as far back as May 2020, which the prosecution obtained during November 2021 and January 2022. 86 on March 7th, 2022, after the extended expert supplemental disclosure deadline, Hurlburt filed a, quote, good faith witness list and a notice of endorsement of witnesses. 87, March 8th, 2022, the defense filed a supplementary motion for discovery sanctions based on the prosecution's February 28th and March 3rd, 2022 discovery production. On March 88, on March 9th, 2022, Hurlburt filed the prosecution's response to the defense's motion to strike witnesses proffered as experts, arguing that the defense was not prejudiced by inadequate disclosures. No, it'll be fine. We're not going to tell you who we're going to bring up. We expect you to pull an expert out of your behind to rebut them, but we investigated ourselves and found ourselves awesome, as you should. I'm just kidding. 89. On March 10th, 2022, the court issued a verbal order striking several prosecution experts, finding that the prosecution failed to comply with Rule 16 and court orders as follows. The court finds a pattern of neglect demonstrating a need for modification of the parties' discovery practices in this case, this trial by ambush. That's exactly what the rules are designed to prevent. I am not finding it willful, but I'm finding a pattern. I am finding prejudice. There is no record to support a pattern of neglect here and prejudice. 90. On March 30th, 2022, Grossberger attended and participated in a Shrek hearing on the qualification and scope of the expert Doug Spence. 91, the night before the hearing, Grossberger called Spence to prepare him for the hearing, and at that point learned that no one on the prosecution team had actually spoken to expert Spence. Well, that's good. I mean, isn't that special? Y'all have like 5 lawyers with hilarious last names. How is no one talking to anyone? Look, I hate talking on the phone about as much as any next extrovert. I much prefer text. I am sorry, everyone. But no one picked up a phone and called this dude who's supposed to be an expert? Sounds about par for the course at this point. And let me tell you that we are on page 10 of 20, you guys. Apparently they did not a thing right. Not a damn thing right. 92. Spence expressed opinions during his telephone conversation with Grossberger the night before the Shrek hearing that were not entirely consistent with what had been included in the prosecution's expert endorsement. 93. Prosecution's initial and supplemental expert endorsement for Spence had indicated that Spence would offer an opinion based on law enforcement canine Roscoe following a scent down to a creek in the direction of the Morphew home, But this was not consistent with what Spence told Grossberger the night before the Shrek hearing. 94. In addition, on cross-examination of Spence, the defense elicited that Spence had, in fact, authored his own report of his investigation, which he had not provided previously. So not only did the state basically not read this man's report, but put in whatever they thought he was going to say, no one contacted him in the intervening time, and then he said something completely different. Again, they are supposed to basically have their reports ready so the defense can ask questions and figure out how to rebut this expert witness. Again, the court had it right. The state was trying to do trial by ambush. They were trying to make sure that the defense had no ability to counter any of the experts. Again, I implore you to look at the Delphi case. You don't have to go to my channel. I would love that you go to my channel. But this same thing is happening to a man that should be presumed innocent and is being held in federal prison as he awaits trial. And there are a lot of things, a lot of parallels to how the prosecution is acting in this particular case, the Morphew case, and the Delphi case. And I bring up the Delphi case because currently, again, a man is sitting in prison, not jail, prison, solitary confinement. And, well, I'm an expert in all things Mo, but even I don't understand why I feel strongly about things sometimes. You know what, men, y'all have it easy. Could you imagine imagine, if you will, men, having deep personal feelings about everything? Holy crap, is it exhausting. So be thankful that you can go from box to box to box and compartmentalize your feelings, because women have all the feelings, and hell, we don't even know how they get there half the time. Or at least I don't. I will only speak for myself. Maybe other people are more self-aware, but all the feelings all the time. Not fun. 95. At that point, the Shrek hearing focused on a possible Rule 16 discovery violation for the prosecution's failure to endorse or to disclose an endorsed expert's report. So they were trying to hide the report that he wrote because maybe it didn't quite go with what they thought. And here's the other side, guys. I realize that there are some people that believe Barry did it, hook, line, and sinker. They are sold on it. What you should want is the prosecution to have every, T crossed, every I dotted, so that, they have the receipts, they have everything going so they can prosecute this man. What you shouldn't want is a prosecution that, tries to cheat the system in order to get quick justice rather than correct justice. Because now, if they say they find Barry Morphew's, the glove fits, you can't acquit, everything. Because of all the shenanigans they have done, that is reasonable doubt. I am working on it. I don't know if I have to set up another account so you guys don't get to see all the Smexy books I read. Although I will tell you, the Yeti ones are ones that I send Mr. Mo late at night because I'm like, oh my God, someone wrote an erotic Yeti story. I must send it to Mr. Mo. I can only imagine. It's my love language. I send him really weird stuff from the internet and sometimes Nancy Pelosi in a swimsuit. Because I just like him to know that I'm thinking of him and want to horrify him during the day. I am not a good wife. But Squid Pro Quo is absolutely right. Again, today it's him. Today it's Barry Morphew. But tomorrow it could be us. I mean, one prosecutor famously said, show me the man, I'll show you the crime. We all break, I think, there was a study done. We all commit at least 4 felonies a day. This is insane. And I will tie it back to my time as a juror. The state wanted me to convict a man for, shooting around a state trooper. But they didn't prove where the freedom seed had gone. They just, said, believe us, bro. Well, I'm sorry, but you are the state. You have access to all sorts of investigative stuff, and I don't go with the believe me, bro, state theory. I don't believe the state trooper that got up there, but, I believe the evidence, and they showed us nothing but, you know, they did show us the force multiplier, and we did not get scoped like every other trial because I was waiting for someone to like put us in the line of. I was waiting for that shenanigans to happen. I mean, they showed us an empty shell casing, but they did not show us where that alleged, pew pew freedom seed went. And the man even offered, this is the other thing, the man offered because he had a metal detector. He said, "It's in my berm. I'll take my metal detector and I will show you because it's got it had been snowing, so you would have been able to tell where a recent, freedom seed had struck." Yeah, but that's the thing. The state has unlimited power. It is definitely a David versus Goliath thing. And all of us jurors were like, they didn't show us what we feel was appropriate to take a man's freedom away, to take a man's ability to hunt again, to have firearms. You didn't show us enough. You didn't show us where that freedom. If they had been able to trajectory out that freedom seed going near a tree that the police officer was at, it would have been difficult, but that would have been proof. I mean, ugh, the state acting gross. Well, now, 96. Grossberger acknowledged in court that because the prosecution had endorsed Spence as an expert but failed to turn over Spence's report, of which Grossberger reported he had no prior knowledge, the prosecutor was not in compliance with Rule 16. Oh, thank you, Cooper. I'm glad. It is. You know what? I am in my full no F's given part of life. I am saying things that I generally just said in high school. I am having a full circle Daria moment. I have my own channel where I basically just say things that I said in high school and point out random, smart assness. And now people like it. Just be yourself. Seriously. It's just hair. It'll grow back a different color. I got 7,100 wigs. Also, just a personal note, Donna will be coming back as a special correspondent because her case is coming up and I have a Rauschbaum wig. Now, I will tell you that the Rauschbaum wig terrifies Mr. Mo because I look like a try guy with slightly higher testosterone than them, or Haley Joel Osment if he lost a little bit of weight. Not going to say I look very comfortable being a guy, but I could probably get picked up by someone on Reddit. Oh, the prosecution admitted that they were wrong. We'll put that down in the calendar. 97, Grossberger proposed the remedy was for the court to strike Spence as a witness. 98, the court agreed on March 30th, 2022. The court excluded expert witness Spence based on the stipulation of the people that they had failed to disclose the opinion or report of their own expert. 99, on April 8th, 2022, the court granted another one of the defense's motions for sanction for discovery violations and determined, quote, "The people failed to put in place a system to preserve emails as ordered by Judge Murphy on June 3rd. The court finds a continuing pattern by the people of an inability and failure to comply with Rule 16 obligations, as well as the court's case management orders." Sorry, guys, I have I have a bid in on it's like this metal box thing that you can use, I don't know, monster screws or stakes or glue. I'm not sure. But it's a steel thing that you can stick on your porch, and it has a lock thing that people can put boxes in and packages. So I'm trying a bidding war with that because they're, I think, originally like 300, and y'all know I will not buy something unless it's Sailor Moon. We are finding a deal, and even then, we're looking on eBay first. Sorry, tangenting, squirrel. Let's get back. So basically, the judge is saying, like, y'all, I'm gonna turn this trial around, and no one is gonna get Frosties. Shape up. This is the judge using nice mommy voice. And as a public service announcement for all people, nice mommy has about 40 tries of telling you something sweetly. Then mean mommy is going to come out, and then pissed mommy is going to come out, and she's going to give you about two warnings. Then if you're Mo, Samuel L. Jackson from Snakes on a Plane mommy comes out. My inner sailor comes out, and I am weaving a tapestry of curse words that I should not be saying in front of my children. I get it. But there are only 300 times mommy can ask you to pick up the fork off the stairs before she just loses it. So he's using nice mommy voice, but they are going to probably get to Samuel L. Jackson mommy voice because we are only halfway through this complaint. Now, 100, in the same order issued April 8th, 2022, the court excluded most of the prosecution's experts, finding the people's actions amount to neglect and arguably reckless disregard for their Rule 16 obligations and duty to abide by court orders. The court excludes 11 out of the 16 of the people's endorsed expert witnesses, a sanction warranted based on the record. The case is set for trial to begin on April 28th. 2022. 101, the respondent was informed by the prosecution team that expert dog handler Spence had been excluded, such that of 16 experts initially endorsed by the prosecution, 15 had been excluded altogether, and 1 had their scope of testimony reduced. Well, I'm trying to be more proactive. I kind of lived in the false sense of security that since I live out in the boonies and the boondocks, that, package theft had not really come to our neighborhood. But I found out when I complained on, look, I call it neighborhood bitch, but it's next door. You know, those apps where like everyone in your neighborhood can tell you if they're missing something or put really passive aggressive, complaints up about people. I call it, or neighborhood bitch, but it's not that, I promise. So apparently there had been at least 5 package thefts and someone following the Amazon and UPS delivery truck around the neighborhood. So I am trying to be proactive and getting most things sent to my P.O. box, but for things that are already on their way and can't be changed, I am attempting to get this metal box thing. And or putting out boxes of kitty litter. I mean, I don't know. I have thoughts. Respondent orders investigation of Judge Lima after series of adverse rulings. Now here's where it gets super de-duper shady. Prosecutor lady is pissed that her expert list is down to 1 with a limited scope. Now, instead of looking at herself in the mirror and saying, gosh, my employees don't seem to be able to, get anything done on time. Nah, it's the judge's fault. He's a mean judge and we must find dirt on him. She absolutely did Oppo research on the judge. Well, yes, Wolf or Fundian, but I have cat litter that's used at home and I can get boxes from Walmart. I'm making my own company, damn it. Respondent orders investigation of Judge Lama after series of adverse rulings. 101, on March 12th, 2022, 2 days after the court hearing regarding the prosecution's deficient expert disclosures, respondent texted Morphew prosecution team 7. The prosecution team had a group text chat thread where all members could text each other and see each other's texts. Now, Hurlburt, Wiener, and Grossberger. Again, the best names for a joke trial. I mean, the law office of Hurlburt, Wiener, and Grossberger. I'd hire them. A petition started by Jules Wolfe. Jules Wolfe has a true crime podcast called True Crime with Jules. 103, the respondent sent prosecution team the petition written by Jules Wolfe, which claimed, quote, the ex-wife of Judge Lama is an advocate of Suzanne Morphew and victims of domestic abuse, end quote. 104, the respondent continued texting other prosecutors, encouraging them to investigate whether Judge Lama had ever abused his ex-wife, Iris Lama. 9, the text message stream between respondent, Hurlburt, and Wiener was filed as suppressed for attorney's eyes only as Exhibit A, along with a contemporaneously filed motion to suppress Exhibits A and B. So we have not seen this, group chit chat message that is along the lines of the Canton group message. I mean, honest to God, do these people not think that people are going to look at, again, why have a group chat professionally? Like, my job is to be snarky and witty on the internet. But if I were professionally in an office area, I don't think I would add all of my snark to, okay, well, I know I would add all my snark, which is why I don't have an office job. Also because I barely can work computers, and oh my God, that would be terrible. Let's see here. 105, the respondent decided to interview Iris Lama because, quote, we couldn't understand Judge Lama's orders that were so egregious against us. He's normally not like that, and we were discussing what was going on, and those two came together. I said, let's see if we can get somebody to interview her and see if something's going on, or if she suspects that he's trying to get back at her, essentially in the most passive-aggressive way, by making this case impossible to prosecute. So we wanted to see what she would say, anything to us or about any of that, or if the actions of the judge may be almost a passive-aggressive move to her. Okay. I need to get the blackboard because this is incredible. This theory is just ridiculous. No, the thing has wheels. Why don't you just pick it up, Mo? Good idea. My genius knows no bounds. All right, let's raise this desk and get me back on screen. Because we have the chalkboard of truth, because I need to Madden explain this thought process. Because I generally say that I think in nebulas of thought, but this is maybe the best jump to conclusion thing I've ever seen. Okay, chair, you're gonna have to kindly move for 2 seconds. Okay. Now, I know I have geeked out about this chalk before, but if you have a chalkboard or anything, or a teacher that utilizes a chalkboard, Hagoromo chalk is the best chalk. It writes smoothly. It's actually a product that is raved about by teachers. But let's Madden this out for a second, because I'm confused. See if I can get this in here. Maybe I can use my no, too much work. All right, so mean judge here. Prosecution team of, well, we're just going to put a burger here. But it's definitely so not, him being mean to them. No, he's trying to get back at his ex-wife. By blowing this case. This is the theory that you have. You're like, no, he's a meanie meanerton. Not we're screwing ourselves with discovery. It's not that. No. Never the prosecution's fault. No, he is passive aggressively trying to get back at his wife. I'm going to need all of the Harvard scientists. I am going to need Mensa members and NASA to figure out that particular conclusion, because I am just, it's glorious. I applaud you as the mother of, oh, awesome. Thank you, Squid Pro Quo. Thank you so much. I am finally to the point where I'm willing to admit that I might need a walker and or wheelchair on really bad days. I've been fighting it for 3 years. And thank you for your help, because I don't know exactly which ones are the best. I do know that I will be doing a segment of pimp out your walker or, wheelchair, because, okay, general thought from the chat, because I don't know if this is inappropriate. It probably is, but if I get a patch on that goes on the back of my seat, if I get a wheelchair that says in the name of cripples, I will punish you in full Sailor Moon font, would that be considered in bad taste? I mean, I do have a cripple pass. I get the little handy capable sticker. So I was just wondering if that would be okay. I mean, I'm still going to do it, but and I'm going to add streamers and possibly my own fog machine. I'm making an entrance. Anywho, let's see here. So this is all a passive aggressive move to get back at his ex-wife. Now, 106, in March 2022, respondent and Wiener called Commander Walker at the Chaffee County Sheriff's Office and asked if he had an investigator to investigate an alleged, prior DV accusation by Judge Lima. 107, Walker refused, telling the respondent she had no good source for investigation. Yeah, the sheriff's like, look, you're going down a path. I am not your Huckleberry. Get Grossberger. He seems like a yes man. 108, respondent persisted and enlisted her own investigator to interview Judge Lima's ex-wife. Awesome possum. I am going full Sailor Moon. I don't know if I'll attach a wig with buns on it, but it might happen. Now, again, she is saying none of this is my fault. This is all the judge's fault because he hates his ex-wife. And while I admit that some people can bring, their outside views and petty into court cases, and judges are human too, I doubt that he's going to nuke a high-profile case just to get back at his ex-wife. Ooh, I am intrigued now. Thank you so much, Squid Pro Quo, and I'm glad you get to use your degree. I am glad that people have degrees in this, so that when people like me finally admit maybe we need help, they have info that can help us. 109, on April 7th, 2002, the respondent emailed Hurlburt and others and informed them that investigator Andrew Corey, who worked for the respondent's office, was going to interview Iris Lima regarding Judge Lama. Sorry. keep saying Lima and it's llama. 110 on April 9th, 2002, the day after expert disclosure sanction orders and 19 days before the scheduled commencement of the Morphew trial, investigator Andrew Corey met with respondent Hurlburt and Weiner and wrote in his notes that the respondent wanted to find out if Judge Lama had spoken to Iris about the Morphew case and whether DV had occurred in their relationship. Footnote 10. Corey's notes and reports are attached as Exhibit B, filed as suppressed, along with contemporaneous motion to suppress Exhibits A and B attached to the complaint. Now, I do wonder, since this has now been adjudicated, if we will be able to get Exhibits A and B not sealed, because I think that that would be very helpful in... I have made no decisions about the case, but I have made... electing myself as judge of the internet, I have decided that this prosecution sucked. That's a legal term. Sucked out loud. Okay. 113 on April 19th, 2022, respondent moved to dismiss case at the pretrial readiness conference, which was 9 days before this trial was scheduled to begin. 114, the court granted the motion and dismissed the Morphew case without prejudice. So without prejudice means that should they find any evidence or believe they have a stronger case, they are not barred from bringing the case against Barry again. The problem with that, from what I can tell you as a juror, is that it's going to be a hard hill to climb to say, hey, look, we totally had this case, but we totally screwed up with the deadlines. Believe us, bro. It's going to be hard, regardless of if they take this entire prosecutorial team out and, out to pasture. You are now going to have a cloud of, corruption, collusion, trial by ambush. I mean, all the shady things. They have, in fact, given up the opportunity to find the best justice for Suzanne Morphew because they were too worried and too afflicted with cranial rectitis. It is deadly. You cannot breathe with your head stuck up your own behind. So please extract it. Or get a friend to help, whichever. But they have now made it to where even if we find the guy with full DNA, if it happens to be Barry, if the glove fits and you can't acquit, there is always going to be so much reasonable doubt because of the way they behaved here. And that really is quite upsetting, because as snarky as I have been, as ridiculous as I generally am, I don't want Suzanne Morphew to have died and been buried in a shallow grave for nothing. I want to find the person. If it happens to be Barry, I don't have any strong feelings about that. But the fact that they foobarred this case so much means that even if they find, the Joker comes out and says, do you want to know how I got these scars? And he's like, well, I was fighting with a bicycle with Suzanne Morphew. I mean, even if you had a man come out and completely admit to this, there is always going to be that doubt now because of what they did here. And it is so beyond frustrating. You are supposed to be professionals. You are supposed to act with comportment, act in the service of justice, not the service of your wounded feelings. Claim 1, a lawyer shall act with reasonable diligence and promptness, Colorado RPC 1.3. So that's Rules of Professional Conduct. 15, Colorado RPC 1.3 states that a lawyer shall act with reasonable diligence and promptness when representing a client. 116, after being placed on notice by the prosecution team, defense, and the court of repeated problems in meeting Rule 16 requirements by not timely disclosing all information required, the respondent failed to ensure that the prosecution team would timely and completely comply with Rule 16's requirements concerning strategically vital expert disclosures. 117, as a result of that lack of diligence, the prosecution's expert disclosures to Morphew were not timely and were incomplete. 118. Even after the court granted the prosecution additional time to supplement their expert disclosures, respondent failed to diligently or promptly assist with expert disclosures. 119. A sanction for violating the court's expert disclosure order, 15 of 16 experts were tendered by the prosecution and stricken, and only one was permitted to testify as an expert. 120. By such conduct, and in each instance described above, the respondent violated Colorado Professional Conduct Rule 1.3. Wherefore, the complainant prays that at the conclusion of this complaint, let's see here. Claim number 2, pretrial publicity, Colorado Rules for Professional Conduct 3.6, subsection A. 121, Colorado Rule of Professional Conduct 3.6, subsection A states that a lawyer who is participating in the investigation or litigation of a matter shall not make extrajudicial statements that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Welcome, Shelby B. And 11, footnote, it says Colorado RPC 3.6, subsection A. This is just a reading of that particular section. Comment 5, there are, on the other hand, certain subjects that are more likely than not to have material prejudicial effect on a proceeding, particularly when they refer to a civil matter triable to a jury, a criminal matter, or any other proceeding that could result in incarceration. These subjects relate to 1, the character, credibility, reputation, or criminal record of a party suspect in a criminal investigation, or witness or identity of a witness, or expected testimony of a party or a witness. 2, in a criminal case or proceeding that could result in incarceration, the possibility of a guilty plea to the offense or the existence of contents of any confession, admission, reading is fundamental, or statement given by a defendant or suspect, or the person's refusal or failure to make a statement. So she is not supposed to be commenting on the fact that he, exercised his right to remain silent. Oh, Sheba, sorry. Again, reading is fundamental, and I forgot hooked on phonics, but I will do better, I promise. I try not to butcher names all the time. It's a goal. So when she was going out there and pushing all of these possibilities, claiming that Barry was a flight risk, these are all very prejudicial statements that she should know not to make. She shouldn't be feeding information to YouTubers, true crime YouTubers. She shouldn't be going on their shows to discuss the case. This is all likely to prejudice or, again, put out there the idea that the state has its man before they've, fulfilled their duty or their burden to prove it. 3, performance results of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. 4, any opinion as to the guilt or innocence of the defendant or suspect in a criminal case or proceeding that could result in incarceration. 5, information that the lawyer knows or reasonably should know it is likely to be inadmissible as evidence of trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Or number 6, the fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and the defendant is presumed innocent until or unless proved guilty. Now, I do think that I will be pulling for Thursday, should we get, or the next time we go, because this will be a series, the next time that I look at this, after we finish the opinion given down by the judge, We will probably be looking at those streams. I will give credit to the streamer. I don't particularly like what they did, but I could see how the temptation would be there if you have a personal connection with the prosecutor, that you might want to ask inside baseball questions. The problem with that, again, is if you truly believe that Barry did it, you are lessening the chances that this goes to trial. You are actively making it so that this case will be a gajillion times more difficult to try again. So, I don't tell you how to live your lives, but I call that a no-go in my book. 122, respondent violated this rule on several occasions, including but not limited to A, on May 5th, 2021, when she told the media Barry Morphew, quote, was taken into custody, and when asked questions, he said he wanted to call a lawyer and all questioning ended, end quote. B, in late August and early September 2021, when respondent appeared on the YouTube channel Profiling Evil to discuss the Morphew case and also made written extrajudicial statements in the public comment section after the podcast ended, wherein she wrote to Jean-Luc Besser and made specific comparisons between Barry Morphew and a prior murder conviction where no body was found, Dante Lucas. C, on September 14th, 2021, when respondent exchanged Facebook Messenger messages with Jules Wolfe of True Crime with Jules, and in her response to the question about whether Morphew might flee, the respondent stated, quote unquote, possibly. D, in June 2021, when respondent texted King in response to a Barry Morphew video, quote, we got him, no worries, end quote. 23, by such conduct and in each instance described above, respondent violated Colorado Rule of Professional Conduct 3.6, subsection A. So it is very rare that the state has 20 pages of things wrong with you. Think back, and the only case I can kind of liken this to is when I am blanking on his name, but the judge in Sarah Boone's case, the current judge, basically wrote a 15-page, no, you're not getting another lawyer. You've had a gajillion chances. I do not negotiate with emotional toddlers. That brief. These are generally short and to the point. The fact that they have 20 pages on this complaint and then 83 pages on the, you shall never be a lawyer again decision means that there was a lot of hinky crud going on. Wherefore the complainant prays at the conclusion of this complaint. Claim 3, prosecutors' extrajudicial comments, and this would be subsection F. So apparently there are so many subsections. Again, why I didn't become a lawyer, because some of the lawyer subsections read, honest to God, like when you are trying to set the time on the VCR and you never could get it, or at least I couldn't. They read like IKEA instructions, and let's just say everything I personally have put together from IKEA may not be sturdy enough to sit on, even if it was supposed to be a stool or a bench. I'm just saying I can't read instructions. Respondent violated this rule on several occasions, including but not limited to on May 5th, 2021, when she told the media so these are the same sort of things, but it looks like it violated another subsection. Now, they didn't put the subsection or kind of what it is that they thought she did, but it's probably the basic same kind of thing. Again, the prosecutors are not supposed to say things that will prejudice the, viewing public, which is in fact your potential jury pool, against the defendant. He is supposed to be presumed innocent. It is one of our absolute bedrocks of our judicial system. It was in fact alarming to hear fellow jurors say, when the defense attorney asked them What would you feel if I did nothing? If I sat here and said nothing? And they were like, well, I'd want you to put on a defense. I mean, don't you have to prove he didn't do something? And I raised my hand up because I was irritated that no one understands the judicial system. I said, no, because it's the state's burden of proof. You don't have to get up at all. It is the state, not the defense, that has the burden to prove guilt. The defense has no burden to prove innocence. And that's when the state's attorney knew he'd done effed up. I'm just kidding. I don't know. Y'all, honestly, I don't know why they let me stay there. But there you go. They picked me, and I was like, and it's all the state. You can file your nails, ma'am. I'll just wait for the state's burden. And everyone looked at me, and I was like, you guys, this is in fact a bedrock foundational, part of our judicial system. Even if you watch court TV or Matlock, you are supposed to assume that this person is innocent. They have to prove nothing. You cannot prove a negative. But apparently, that was news to everyone. Claim 4, responsibilities of supervisory lawyer in the rules for professional conduct, 5.1a and b. 27, Colorado RPC 5.1a and b provide a partner in a law firm. Law firm refers to a partnership, professional company, or sole proprietorship, or any other entity through which any lawyer renders legal services. It also refers to a corporation, organization, or government office in which lawyers render legal services. So there you go. You have to be a gaggle of lawyers, a snark of lawyers. I don't know. We'll have to figure out a name for a group of lawyers, because I know a murder is a group of crows. A kaleidoscope is a group of butterflies. I don't know what we call a group of lawyers. Billable hours? Anywho. And a lawyer who individually or together with other lawyers possesses comparable managerial authority in the law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct, and B, a lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to rules of professional conduct. 128, respondent violated Section A of this rule because she failed to make reasonable efforts to ensure the 11th Judicial District Attorney's Office had in effect measures giving reasonable assurance to that all of the prosecutors in her office conform to the rules of professional conduct. 29, the respondent failed to make reasonable efforts to ensure that her subordinate prosecutors were adequately trained regarding discovery and timely disclosures, including expert disclosures, and failed to make reasonable efforts to implement adequate office procedures to facilitate compliance with Criminal Procedure Rule 16 and related orders from a tribunal relating to discovery and disclosure. I like it, Wolfram. A conspiracy. I think Sheba, in sarcastic tone, you might call a group of lawyers a quarrel or a greed of lawyers. These terms play on common stereotypes about lawyers being argumentative or money-driven. I like all of them. I shall use a quarrel, greed, or conspiracy. I am not saying that man's name. I'm going to have to see him again when he retries Karen Reed. And honestly, you guys, I don't know how I'm gonna handle it. And I'm not getting a lolly wig. I mean, I will just get a bald cap and glue 6 pieces of yarn on it in that little fin thing he has from the early 90s or early aughts. Sorry, late 90s, early aughts. He was very, very cool with the little stick-up bangs when he still had hair. All right. Let's see here. 30, the respondent failed to make reasonable efforts to implement adequate measures to ensure administrators and prosecutors would consistently comply with the rules of professional conduct. Respondent violated Section B because she failed to make reasonable efforts to ensure Morphew prosecutors could comply. Ooh, I like that. I love that we're all, I love you guys. I love that my chat can joke and play. I mean, we understand at the bottom of this, someone lost their life. Some daughter, two daughters lost their mom at maybe a time when they were finally willing to accept, motherly advice again, because, those teenage years can be hit or miss. And they also missed the future when their mom became a grandma, when their mom walked them, helped them pick their dress. So we get all that. But in order to deal with that, sometimes we use dark humor. And I'm glad I found my dark humor tribe, the Church of Mo. We are not being disrespectful to victims, but we will take care of ding battery. And this is ding battery to a criminal level. And thank you so much, Squid Pro Quo. Number 32 or 132, even after respondent was on notice, her prosecution team had been sanctioned for discovery violation. Respondent failed to verify that designated experts had been interviewed as to the scope of their opinion prior to being disclosed. Failed to verify expert disclosures had been reviewed before filing, and failed to verify that all material in support of expert disclosures had been disclosed, and failed to ensure that all disclosures were timely, and thus did not make reasonable efforts to ensure prosecutors in the Morphew case were complying with the rules of professional conduct. 33, by such conduct, respondent violated Colorado Rule of Professional Conduct 5.1 A and B. And these are simple things, guys. These are not things that are out of the blue, a crazy, deep magic, Aslan talking to the witch, don't talk to me of the deep magic. I was there when it was written. I mean, this is not like some random rule that someone put in, like you can't have an ice cream cone in your pocket on Wednesday. These are normal, everyday things that lawyers should be competent in, you would think. But she wanted that prize. She wanted that conviction more than she wanted the truth, is my read on this. She had already made up her mind, regardless of what the experts thought. She thought that she could, just get a judge that was going to rubber stamp her, even if they made mistakes. It's just really, really gross. Attempt to violate the rules of professional conduct and conduct prejudicial to the administration of justice, Colorado RPC 8.4, subsection A, and Colorado RPC 8.4, subsection D. 134, Colorado RPC 8.4A prohibits a lawyer from attempting to violate the rules of professional conduct, knowingly assisting or inducing another to do so, or doing so through acts of another. 135, Colorado RPC 8.4, subsection D prohibits a lawyer from engaging in conduct that is prejudicial to the administration of justice, and they have a footnote. I think I'm the only person that ever gets excited about footnotes, but I love them. 13, RPC 8.4 comment, subsection 5 states, lawyers holding public office assume legal responsibility going beyond those of other citizens. A lawyer's abuse of a public office can suggest an inability to fulfill the professional role of lawyers. It's almost like there was, an ethics book that this woman had an ethics, elective in college, and she just skipped all that lawyer ethics stuff. She's like, just give me the bar exam. I'm ready. Let's see, 136, respondent in her role as elected district attorney instructed her chief investigator, Andrew Corey, to interview the ex-wife of Judge Lima, the judge who was presiding over the People versus Morphew case. Now, this is beyond the pale. Again, I have never seen a case I've only been watching cases for 3 years, though, with that caveat, where the state's attorney decided to start doing opposition research on the judge. And can I applaud this woman on the long jump, to conclusions that she did? I mean, she is a gold medal, like, jump to conclusions, because it couldn't be her fault, but that judge was trying to be passive aggressive to his ex-wife. That makes sense. No, I'm sure you can tell the guy from, Profiling Evil that it was the judge. 137, the respondent did so in an effort to uncover information about Judge Lima that could cause his recusal or disqualification from continuing to preside over the Morphew case. So instead of, saying we would like a different judge, they decided to ruin this man's career and reputation. It's a bold move, Cotton. It's bold strategy, Cotton. Let's see how that works out for her. I hope she likes, being a correspondent for Law and Crime. Maybe, like I said, she's probably going to go join a podcast with Coffin Digger. So I'll be happy to roast the hell out of that. Coffin Digger, you and I have some beef, okay? Again, you do not troll a little girl with a chronic illness. Not on my watch. You will get honey badgers coming out the woodwork because we don't mess with kids, okay? And that seems to be all Coffin Digger can do, is mess with children and people that don't have the power to fight back. Well, as a butthole avenger, I avenge the people who are buttholes for the victims of said buttholes. I have some thoughts, and we might do a video. But that being said, let's get back on track. Now, 39. The respondent persisted in having her own investigator interview Judge Lama's ex-wife, even after Commander Walker refused to do an interview with Judge Lama's ex-wife due to lack of credible evidence to warrant an interview. So that Commander Walker, you kept yourself from being, in a whole big trouble because you were like, that seems shady. The one smart man is Commander Walker, Texas Ranger. I added the Texas Ranger part. But if he doesn't add that to everything, I don't know why he has Walker as a last name. Number 141, the respondent's actions constituted an abuse of her power as an elected. Okay, so I am personally offended by this one, and I don't personally get offended by a lot. But Jennifer Coffin Dingerbat, she was the one who trolled through Maya Kowalski's Instagram photos and found her going to homecoming, and then decided to give them to Johns Hopkins All Children's Salk Hospital to claim that Maya was faking her illness. Now, personally, I have complex regional pain syndrome, and I got it 3 years ago when I was 37, and it has been like hell to adjust to this, to adjust to having a chronic pain condition, to have to deal with not ever buying, shoes that have laces anymore, to have to train myself, to have to work hard to even wear boots because I live in Indiana and I cannot wear Birkenstocks every day, especially in the winter. So I honestly have to train my foot and deal with pain so I can put a pair of Uggs on and look like a basic, pumpkin spice mom. And if you look at those photos of Maya going to homecoming, chronic painers can see it. She is stiff. She is not smiling with her eyes. She is most definitely in pain, but she is still going because, those of us with chronic pain should not have to do performative pain dances for you in order for you to believe there's a problem. We have good days. We absolutely have good days where maybe you would never notice that we're in chronic pain because we've learned to kind of put a good mask on it. We've learned to notice this. Oh, yes. I am not a doctorologist. I have no experience beyond my own personal one. But to require a child who has lost her mother, to abstain from anything remotely comparative to a, normal life because you want to side with evil. Again, pick on me, Coffin Dinger. I'm a grown ass woman and I don't give two craps what you think of me, whether you think CRPS is, you know, fake, whatever. But the fact that you go after children, the fact that you went after Maya and you went after the Acra car guy's wife and children on Instagram, I mean, how dare you? How absolutely dare you? Again, pick on people your own age, your own size, who would be glad to get in the ring with you verbally, not physically, but verbally. If you really want to have this, throwdown about whether CRPS is real, contact me. Get in touch with my people. We'll have it. You can tell me how you think Johns Hopkins was just great for, testing Maya by leaving her bedbound and, unable to get to a toilet to test her CRPS, making her walk, making her, touching her, hugging her. When I am having my flares, like I did yesterday, air hurts. So you imagine, because what it feels like when you touch someone when they have a flare with CRPS, a hug can feel like breaking your ribs. A touch can feel like you are being stabbed. And these adults, these nurses, these medical professionals decided to test this child to try to prove her wrong, saying it was all in her head. Do you know how many times I have heard that? I am just done. I am just done. Yes, I have a chronic condition. Yes, you will see me walk with less of a limp some days on my good days, because I don't publicize the days where I consider, okay, I have 10 steps to get to the restroom, or I could crawl, but that'll really hurt my entire leg. So I have to call Mr. Mo. Or when I was out at a, fun family function and I had to have someone take me home because I could no longer stand it. I had about 4 lidocaine patches on. I had all of my, meds current. So I thought I could sit there and just be fine. But the wind was hurting. And I'm 37. And this has absolutely upended everything in my life. And I did not deal with it well for the first 2 years. I threw myself an entire pity parade. I was sad and depressed. And the one thing that helped me was joining YouTube and realizing I was not alone in, dealing with chronic pain or having to, get a stand-up, sit-down desk. So I can stand on the days that are good and I can use my walking pad. And then on other days, I can sit down. And to say I really struggled, I absolutely did. And that's what pisses me off, that she went after a child that lost her mother too. You would think that there would be something in you that would stop you from doing those, for attacking, for being on the side of again, destroying a girl who already lost her mom. Because let me tell you, whatever amount that J Hatch has to pay, whatever amount that, they decide is appropriate, or they try to weasel out, will never bring Maya's mom back. And that's all she wants. Ask Maya, does she want a pile of cash or does she want her mom back? Does she want that hug that the judge denied right before she unfortunately took her own life? Because I guarantee you that Maya would rather have that hug from her mother than all the money in the world. And don't think I've forgotten about you, DCFS. We're going to have a chat too. Elect me for president and I will fire every single person at all of these child protective agencies. And then I will go through a comprehensive rehiring process and have Elon Musk figure out why things are so messed up If he's already going to do, an audit on all the stuff, I would get him in for DSF, because I am so effing tired of child services losing or giving back kids to parents that take them out. Okay. I have released the rage. We are back on tangent, but I had to get this out because there are very few things that make me want to start internet drama, because I think it's dumb as hell and you waste a lot of time changing no one's mind, because the person you're fighting with is never going to change their mind, most likely, regardless of facts spewed. This is a fight I'll take on, because no one bullies a child in my watch. I have adopted half of the internet plus. You do not screw with my kids. You do not screw with my friends. You do not screw with a young child who has lost her mom. It doesn't happen. And I have a whole rant video where I probably had a different hair color, but it is there. It's my first rant / screw you video. So proud. It's a proud moment. But anyways, let's get back to the current injustice instead of I could make a stream just making fun of that woman, but ugh. Just ugh. She's that stuff that, you cough up, those tonsil stones. It's just not good. Allegedly in Minecraft, Raja Mahand, I know you are watching me. I'm probably on a list, but these are all opinions. He really is. I keep bringing him contestants. Okay, so basically what this is saying in this particular complaint thing is that, again, she tried to find opposition research on the judge to try to get him. Wise Angel, I'm so sorry that you've been a flare since the 3rd of May, since an elderly man plowed into the back of your car. Yikes. And it is absolutely true. I didn't know until I knew. You don't understand having to pep yourself up to get out of a car when you know getting out of a car is going to hurt. How to tell your husband, look, I thought I was going to be fine. I really want to be at this family thing, but I really don't want to cry in front of people. So can someone take me home? These are things that Penny, I was just joking. To be fair, I don't know Elon personally. That he's never given me Starlink. I was just joking. I want someone to come in and reform these departments. I want the people who are actually out in the field to be the ones that help create policies. I mean, to a lesser extent, imagine working in retail. I'm sure all of us have worked in retail. I still have PTSD from listening to Christmas carols all the time. But if you imagine the policies that are made by the pencil pushers that have never worked in an actual store, that's the kind of thing that really ticks me off. We have people that know how things work that are on the front line, but we get corporate telling us how to add 15 steps to something that was relatively easy. That's the same sort of philosophy I would go with. Obviously, I am not going to win the presidential election unless 2024 goes full shining, brilliant, absurd diamond. In which case, my mother is going to be so disappointed I did this. Did you run for president? Are you kidding me? And hand jobs for all, that was your slogan? I can't even go to church now. My mom doesn't have a Southern accent. This is my sort of mom to 11-12. Anywho. All right, respondents' extrajudicial statements become more brazen. Oh, she decided to fight with more people on the internet. 144. On May 22nd, 2023, a CA case was initiated against William Henry Jacobs stemming from the death of a 10-month-old child. 1:45, approximately a week later, Brooke Crawford, mother of the child, was charged as a co-defendant on June 2nd, 2023. 1:46, the charges arose from an incident that occurred while the child was in Mr. Jacobs' care. 1:47, respondent subsequently formally charged Mr. Jacobs with murder in the first degree and 2 counts of felony CA resulting in death of a 10-month-old child. He was also charged with a misdemeanor of animal cruelty. 1:48, Miss Crawford was charged with felony CA resulting in serious bodily injury, misdemeanor child abuse, and misdemeanor animal cruelty. 1:49, on August 1st, 2023, a television interview aired with a respondent. Now, this one pisses me off. This one really pisses me off because she ran her mouth, because she wanted to be Billy Badass all over the internet. And, Sally speaks a lot, just all around. This child who lost his life or their life, I'm not sure if it's a girl or a boy. Oh, it's a boy. Sorry, Edward. Lost his life in a case that looks horrific and terrible. And you guys, that was my biggest worry when I got jury duty. I did not want a kid case. The only way I can cover them, the Gannon Stalk case, and, stepping in and, being second chair with Baker on the Harmony, dang it case, from New Hampshire, was because I didn't have to see the pictures. I didn't have to see those terrible photos of, horror that Gannon went through. I didn't have to see Harmony's body. I didn't have to. I could divorce myself and snark at the defendants who I thought were pretty gross. Letitia, I am still working on all the wigs for all your characters. Do not worry. I am coming for you, ma'am. I have all the wigs and I am ready. I just need to get my green screen figured out, but more correspondents will be joining Newsy News from time to time. But let's see. So because she decided to run her mouth, she jeopardized this case. Oh, Jude, congratulations. Finally got to the laptop. Woo, great chat today. Just popped in to say hi to you and wish you all a good day. Thumbs up on the way back out just to watching. Thank you so much. And for all the lurkers out there, I was nervous to join chats, but this is a great chat. So if you want to dip your toe in a channel that's not super huge and a friendly chat, always welcome. And thank you for being a member of the Church of Mo for 9 months. So I appreciate it so much. I appreciate you guys' support so much. I mean, having a group of people to wake up and do Newsy News or whatever stream that I decide to babble on, it really helps to know there are people that get it and people that get it when I have to cancel streams or reschedule because I'm having a bad day. I mean, it is really helpful. All right, so 150, as of the date of this filing, KRDO's video and audio news story can be accessed. I need to write this down so I can look it up from this thing. So let me see if I can pull that up because I've gone full rabbit hole. I am so sorry, you guys. Fremont County District Attorney believes accused baby unaliver got with baby's mom to just, quote, get laid. Yeah, that's prejudicial. No, I do not. I have no tattoos. I am thinking about getting that little piercing that's supposed to help you with migraines. But with CRPS, I will probably get temporary tattoos and never get a tattoo just because any sort of prolonged irritation, especially on my left side, I believe so. I've adopted most of the internet and chat, so everyone's my kid. I have a gajillion kids. Welcome, JKD Buck. Honestly, I really have. My husband's like, "Are you adopting more people?" This is why I can't be around any sort of puppy rescue and or kitten rescue, because I would just adopt them all. I need someone there saying, "We have enough cats. You can't room them all." All right, let's see what this woman babbled about, because yes, this would be considered more prejudicial because she has just put out there now that he was only there to get laid. Now, regardless of, a jury saying, yeah, we can ignore that, that's still going to be in many people's minds. This is still going to be an incredibly high hurdle, especially in a child case where emotions are already high. The 11th Judicial District Attorney minced no words when she provided 13 Investigates with details on the case involving a 21-year-old man accused of unaliving a baby at Motel 6. On May 21, 10-month-old Edward Haynes was found unresponsive in Cannon City motel room. Edward unfortunately passed away at Children's Hospital in Colorado Springs. The circumstances surrounding why the suspect, 21-year-old William Jacobs, was living with Edward and his mother have been or are now unknown or have been unknown. But now the 11th Judicial District Attorney, Linda Stanley, is sounding off on the case. Well, of course she's running her mouth. According to court records, Jacobs had just begun living with Edward's mother, Brooke Crawford, before the baby's passing. Quote, "I'm going to be very blunt here. He has zero investment in this child. Zero. He was watching that baby so he could get laid. That's it, and have a good place to sleep," Stanley told 13 Investigates. "I'm sorry to be that blunt, but honest to God, that's what's going on." That's what we would call an inappropriate statement. I don't care if you think these things as a prosecutor. I really don't. You're entitled to an opinion, but you are not entitled to mouth off again in the pub or in the media. That is not what you are allowed to do. You are not allowed to try this in the court of public opinion. Sorry, I'm just pulling it back to where we were, which is about 15 pages in. But you're not allowed to do that. That, in fact, really, again, puts in jeopardy a case that should be a slam dunk if you have all of the evidence, all of the ability to get this child justice, and you want to come out and give your Ricky Lake impression of this case. That is not your job. Commentators can do that because we have no skin in the game. We are not trying this. We can have opinions and speculations. Now, I always try to tell you guys when my thoughts are speculation only, because I do want to make that distinction. I do want to be honest with you guys and try to be ethical. But when I have more ethics than the prosecuting attorney, I am getting ready to do this. I don't want to have to do this to a prosecutor, but that is a one-way ticket to Snake Island. If you have made it impossible for this baby to get justice here on Earth, dumpster water human. Allegedly, not adjudicatedly yet-ish. Now, during the interview or the television interview on Channel 13, the respondent made the following statements about defendants Mr. Jacobs and Miss Crawford. Stanley, I think she saw a live-in babysitter. Now she can just really pound out the hours, right? She's got a live-in babysitter. Now she doesn't have to worry about anything, right? Rice. DA Linda Stanley is speaking about Brooke Crawford, a Cannon City mom charged in this CA's case, resulting in death. Her 10-month-old son, Edward, was left in the care of William Jacobs back in May. Police say Jacobs told detectives that the baby was victim of shaken baby syndrome, allegedly. Again, I don't know if this case has been adjudicated, so we have to assume that this man is innocent regardless of the charges against him. Stanley, I just had so many buzzers going off when they said the boyfriend was watching him. You jumped to conclusions, ma'am? I thought you were going to wait and look at evidence. I thought your whole job was to go where the evidence shows you. Now, this does seem to be fairly cut and dry. He was the only one with a child. And, then the child was unresponsive. But still, you are not the investigator. You are not Sherlock Holmes. You are not Nancy Drew. Hell, you're not even Nancy Grace. I am going to get on such a list for that. Ursula's going to be like, how dare you? I'm taking away your voice. Too bad, ma'am. I already have legs. They don't really work, and I already got a husband, so really have nothing to bargain my voice away for. Also, who did the casting for the new Little Mermaid live action? Because I swear to God, Nancy Grace, you just need to put purple makeup on her, and she is dead ass Ursula right there. I call her Ursula. If you have a problem watching her show, just imagine her purple, and it makes it much more enjoyable. I'm just telling you as a friendly piece of Mo wisdom. I can only give you that. Oh, yeah, Murder, She Wrote. Definitely. Don't want to forget that. Matlock, Special Justice, SUV. Or, yeah, SVU. I always call it SUV. Let's be honest. I don't pay attention to details. Okay. Rice. While the police investigated the case, the child passed away at Children's Hospital. That's when DA Stanley's office upgraded Jacob's CAA charges to first-degree murder. Oh yeah, Columbo. I forgot that. We need more good bald cops. We need a Columbo here, because the state troopers seem to have a dedication to baldness, but not the truth. At least in Canton. They should be stripped of their bald heads until they, fly right. No one's allowed to shave their head anymore in Canton PD until, they learn integrity. They'll be like a reverse Samson, so we'll know they're back on the path of good when everyone turns up bald. Stanley, there's no witnesses, there's no nothing. There's a whole lot of things indicative of prior incident with that baby. So they have what we like to call no concrete circumstantial evidence beyond the fact that the man was there with the child and something obviously happened, because children don't pass away on their own with traumatic brain injuries. Oh, you're right. I am thinking of Kojak. Oh, congratulations, and thanks for joining so much. I'm glad you found this stream, and good luck on your stream. All right, Rice, prior abuse that Stanley says is direct results of Jacobs having direct access to the child he didn't care about. She says the pair moved into Motel 6 together mere days after meeting one another. The DA tells 13 Investigates that criminal evidence points to a relationship where the child was not the first priority. Stanley, without the caring factor, without the love factor, then a baby's a pain in the ass. Jesus, ma'am. You just wrap this all up in a bow for this. You have now, what I love is that, again, the law can never go into your present sense, feelings or contemporaneous feelings. They can show it using circumstantial evidence that you had mens rea or a guilty mind, but they can't tell you what they were thinking. She is over here narrating an entire headcanon of what happened instead of just giving the facts. This woman is creating a narrative that will be impossible for the parents to, prove a negative. They can't prove that, she didn't get with this guy because, she only wanted a babysitter. That's very hard to prove a negative. And this woman is setting up to where no jury, and especially in a child case where everyone is pitchforks ready, no trial, everyone's emotions are incredibly high, understandably. This is absolute misconduct. The Rice. The DA says that just before the baby sustained his injury, Jacobs had been released from a youth correctional facility. She said Jacobs was previously convicted of a crime for which you would have to register, if you catch my drift. Now, this is also very poor professional. You are not supposed to bring in prior guilty acts that could prejudice a jury. There is a reason that there are entire hearings in limine or before the trial to address these things that can and cannot come into trial by in theory, a unbiased person that can adjudicate, oh, you know what, this is hearsay. Look, I understand you don't like the guy. He's accused of something heinous, but you can't bring in the fact that he was arrested for drunk driving. It has no real, again, she is poisoning the water. She is salting the ground to make sure that these people don't get a fair trial. And regardless of what they do, even Sarah Boone, who I think vaguely acts like a human sometimes, even she deserves to have an impartial jury. Now, I think that after just one day of her creepily smiling at them, they may make some, ad hominem or judgments. That creepy smile, I'd be like, this heifer is looking at me again. Make sure I don't bring a Samsonite to court. Let's see. So again, she is putting out personal criminal information that is off limits. Stanley, I mean, I'm going to be very blunt here. He has zero. So this is where she went just off. Rice, today we reach out to Jacob's attorney for comment on Stanley views of his motives in the case. We are still awaiting his response. Jacobs is due back in court later this month. Again, it is a trick. It is a setup. It is like going up and asking someone, so when did you stop, laying hands on your wife? It's a negative that you can't prove, that is very difficult to prove yourself innocent, but she is out there spreading this on public, television. 152, an article online that accompanied the news video went on to include the respondent's comments about Mr. Jacobs' ability to flee as follows. Quote, the 11th District Attorney says she's worried that Jacobs would be gone. Doesn't this seem familiar? She seems to think everyone's a flight risk. Let me tell you, if they were living in a week-to-week hotel, they probably don't have the money to run off to Fiji. Now, they can probably run a couple places in country, but I doubt they're going to Fiji or some non-extradition country. The respondent stated, I said you got to hook him because he's going to be gone. He knows what's going on. He's no dummy to this process and what's happening. He knows what he did. 154. On August 8th, 2023, defense counsel for Ms. Crawford filed a motion to dismiss for outrageous government conduct based on the respondent's statements to Sean Rice at KRDO. 155. Notwithstanding this filing, respondent did not contact KRDO to request that the video or corresponding written article be removed from its website. Claim 6, pretrial publicity. 156, Colorado Rules of Public or Professional Conduct 3.6a states that a lawyer who is participating in the investigation or litigation of a matter shall not make extrajudicial statements that a lawyer knows. So this has to be another case that she's done this again. 157, even after she had already suffered the consequences of her extrajudicial statements in the Morphew case, respondent continued with more brazen statements. 158, respondent violated this rule when she made extrajudicial statements to KRDO reporter Sean Rice, which she knew reasonably should have known would be disseminated by means of public communication and would have a substantial likelihood of materially prejudicing an adjudicative proceedings in the Jacob and Crawford matters. 159, as the elected district attorney, respondent's stated belief of the defendant's guilt or innocence is inherently prejudicial. 160, her statements had a substantial likelihood of materially prejudicing Jacobs and Crawford's trial. These cases were charged as felony under media scrutiny, and respondent offered her opinions as to Mr. Jacobs' intent, his prior juvenile conviction, and his guilt. 161. Respondent also made statements about Ms. Crawford's character, judgment, and motives. 162. By such conduct, the respondent violated Colorado Rule of Professional Conduct 3.6a. Claim 7. 163, Colorado Rule of Professional Conduct 1.8f states that a prosecutor in a criminal case shall refrain from making extrajudicial comments. Okay, so y'all, she had the ethical handbook. I'm sure she looked at it, maybe had her friend or her people look at it. But there are, it looks like, multiple professional rules of conduct that tell you not to do this. The fact that they have it in multiple places, that this is terrible, this is not what's intended, and they go on to reference it in other rules. You should know. She knew what she was doing was absolutely wrong. She knew what she was doing violated these rules of conduct. She had to know and figured she could get away with it. And that's what I don't like. And I really don't like that now she has put in a child's case, a case of horrible things happening to a baby. She has put that in jeopardy. This child may never have peace, or he'll never have peace on this earth, but he may never have the justice we are able to give on this earth, because she decided to run her mouth and be Miss Chatty Cathy and tell everyone what she thinks. Ma'am, you are not a YouTuber. You are supposed to be a prosecutor, not for very long anymore, but there are a difference. You obviously don't understand. 164, respondent's statements to Sean Rice at KRDO regarding Ms. Crawford's. So this is basically a repeat, but it does fall under another subsection. So those are all of the crimes that she's committed. Now, Wednesday, when we come back to this, we will be reading the actual judgment, where I am sure that this judge gets all of the, ma'am, you done screwed up. Like, just no. So this is an 83-page document. I mean, and the footnotes. Oh my gosh, I'm geeking out. I love footnotes. Look, I'm a very strange person. My first crush was Alex Trebek when I was 12, which scared my mother, but I was more, interested that he had all the answers and he seemed really smart. In that mustache. That's a Tom Selekian mustache, to quote Linza. Okay. Tom Selleck's mustache. Anywho, we will be going over all of this. We will be going over what the judge says, and it is very rare for a public, attorney to get, or a DA to get disbarred, but they are going to disbar her unless she comes in with an appeal that works. But generally, the longer the response, the more receipts they have. So thank you for joining me today. Don't forget to be on the lookout for Nightly Newsy News. I will be putting up that stream. We talk about all the news. I don't generally get into politics other than to report on very high profile breaking news. I generally try to find the true crime, upcoming criminal trials that we might want to look at, and just absurd stories that I find, like this morning, just to give you a taste. Corn Hub, or, Prawn Hub, had a significant drop in their viewage during the presidential debate, so much that they were able to quantify it. And it seems like the viewing went down in swing states. So make of that what you will, but people stopped watching their stepmoms get stuck in wash machines, or pizza delivery men that, got a very special tip until the tip, really. I mean, it mostly only went down until the first commercial break, because we have no attention span, but there was a lull in the desire to find a pizza man or a plumber who could help with all sorts of extracurricular activities. Let's see, Sarah Boone, Daniel Boone, or Boone's Farm. Which works best on a bear? You throw the booze and Oreos and hope it's one of those bears that have become acclimatized to humanity, and he understands that Oreos are awesome. I mean, not so much the cookie, but the cream filling. Look, the youngest, most feral gets that from me. I am not going to lie. The cookies are just containers to hold the cream filling. I wish they would just sell a jar of the cream. Okay. The deflating me knows that that is a bad idea and would be my kryptonite. My inner Cartman is like, yes. Sell only the cream filling. I will buy it. Anywho, I have tangented enough. I've got to rotate laundry, and then it's off to pick up feral boy children. But I will see you guys tonight for Nightly Newsy News, where I pull all of the ridiculous, absurd, and 2024 understood the assignment crazy stories that will fill and break your bingo cards. And that is at 7 p.m. Eastern Time. So there you go. Oh, good Lord. I'm glad my eight-year-old just tells me that God is karma's boss. So if you want karma to get someone, you should pray to God. And I was like, honey, sweetie, I am the world's worst Christian, but I don't think we're supposed to pray for God to smite people. Of course, I said that, and then I prayed for God to make sure that every shart became a full-on art for the person who stole my medication off my front porch. Again, he gets some things from me. I will see you guys tonight. I'm going to let you go. I am going to go do laundry. Don't be peanut butter and jealous. I have a glamorous, glamorous life. And maybe mop some floors. I will see you guys at 7. Have a great rest of your day. Bye, guys.